Good evening, everyone. I'm going to begin the Planning Commission's meeting this evening and call to order, and
I will call.
roll call.
Rodriguez? Present. Swift?
Here.
Green? Absent. Fragoso? Here. Kierline? Gonzalez-Parber? Here. Chair Newton?
Here. And just for the record, I'll note that Commissioner Caroline will come and join us after public hearing item number 1, for which she is recusing herself. So next we'll go to approval of the agenda. And does anyone have any comments, changes, a motion regarding the agenda? Comments, questions, motion?
I motion to approve the agenda.
Second.
All in favor?
Aye.
Aye.
Any opposed? Commissioner Rodriguez? All right, so we have Commissioner Swift, Commissioner Fragoso, Commissioner Gonzalez-Parber, and Commissioner Newton with ayes to approve the agenda. Commissioner Rodriguez, a no. And just a little out of order, Commissioner Rodriguez, do you want to give us a reason why you disapproved?
I would like actually to have Cascade and Fawn moved up on the agenda because they're smaller items and they're individuals, but in the past we haven't necessarily agreed with that. So, and I think ordinances should be at the end.
Are they here? Do we know that?
Could the audience give me a show of hands? How many people are here to talk about the cannabis regulation? Okay. And again, by a show of hands, anyone here for 407 Cascade Drive?
I have some.
Yeah, the applicants, through the chair, have left temporarily. So.
Okay, and they're probably waiting for us to get to that item then.
Yeah, they're probably running down here right now.
And then, how many people are here to talk about the 5G ordinance? Okay, and Fawn Ridge Road and the development standards for the PDD development district zone. Okay, thank you. So Commissioner Rodriguez, I think because it was already announced this way and people are sort of gauging their appearances here at the Women's Club on watching us and how long it takes, we'll just move on. Thank you, though. I appreciate it. I'm going to read the meeting protocol. The chair shall maintain order at the meetings in accordance with Robert's Rules of Order, and the commission has the responsibility to be a model of respectful behavior in order to encourage community participation and citizen input at commission meetings. The commission and the audience are expected to refrain from using profane language and/or ridiculing the character or motive of commission members, staff, or members of the public, and to maintain the standards of tolerance and civility. And now we will open up the meeting for public comments on any non-agenda items. So anyone wishing to address the commission on matters that are not on the agenda but within the jurisdiction of the commission may do so now. Please state the matter on which you wish to speak. Matters not appearing on the commission's agenda will not receive action at this meeting but may be referred to staff for a future meeting. Presentations will be limited to 3 minutes or as otherwise established by the commission chair. Persons are not required to give their name or address, but it's helpful for speakers to state their name for the record and whether or not they are a Fairfax resident in order that the secretary may identify them. So if anyone has any public comments on non-agenda items, please come on up and speak. And seeing none, we will close the public comments on non-agenda items. And there are no items on the consent calendar. So we will move into public hearing item number 1, which is the continued discussion and consideration of an ordinance to permit and regulate adult cannabis businesses. So Garrett and Ben, I think you guys are going to present the staff report.
Great. Good evening, Madam Chair, members of the commission. So what we have here is give you a little background, kind of go through things similar that we've done in the past, kind of lay out what we think would be a suggested process, and then we can go from there. As background, really the Planning Commission is your 4th meeting to discuss the topic, and what we're going to do is really follow the same format we followed the previous meetings as well as the council in terms of the topics. And then what we've tried to do is, as we get to some items, what we'll do is we'll ask, kind of confirm that consensus we think was reached on some items, and then you'll get to some topics in which there really wasn't consensus, but we tried to lay it out to help you get to the decision-making process. And so let's kind of walk through it and see where we can get to. And so if you look, there's all these categories right here. And so we're just kind of going in this order. One was a category we've called to eliminated categories of use. With that, what the commission, the consensus was reached, and it kind of matches the council in terms of not allowing distribution of cannabis products, not allowing for the commercial cannabis cultivation or cannabis testing laboratories. However, the Planning Commission previously indicated you want to further explore the concept of micro-business and manufacturing of cannabis. Those were the 2 categories that the council actually did not want to allow, but the PC wanted to further explore that discussion. And so you'll see attached to the staff report that we gave you more information we had previously given to you on micro-businesses. Bureau of Cannabis Control regulates micro-businesses. California Department of Public Health regulates manufacturing. I think I indicated the town council wasn't really supportive of manufacturing. They thought it wasn't suitable. Town council also stated that micro-businesses could maybe be a large-scale type use beyond what they were really comfortable with. Planning Commission indicated you'd like to further explore that. One recommendation we have for the Planning Commission is, maybe one suggestion is you move forward with an ordinance that adopts the council ban on micro-business and manufacturing, but inform the council that you'd like to revisit that issue in the future. So that way you could have a discussion on micro-business and manufacturing at a future meeting, and maybe that allows you to make some decisions tonight regarding cannabis, because I think that in itself is probably another meeting in itself to get into that level of detail. So that's the suggestion of staff. In terms of temporary cannabis events, the PC reached consensus to prohibit cannabis temporary events. In terms of continuing to allow commercial medical cannabis dispensaries, the PC reached consensus to continue to allow them. In terms of personal medical cultivation, the PC supported the council direction to limit up to 6 plants, whether for medical or non-medical purposes, may be grown indoor or outdoors, so long as the total number of plants does not exceed 6 plants per property. I think we talked about some clarifications of using the state definition of mature plant. State law does allow 6 plants per private residence, so it'd be 6 plants per private residence. The commission did say let's keep existing outdoor cultivation standards, and let's also keep the exceptions for medical marijuana. Under our existing code, we have a limit of actually 18 plants outdoor, but if that went to 6 plants, someone could still apply for an exception. Basically, they have a doctor's note saying they need so many plants for their own personal medical use. And what some of the still outstanding issues for the Planning Commission to talk about was how to handle outdoor cultivation for multifamily units. Did you want to establish a limit? Are balconies a concern? I think staff has some information. We reached out to some landlords to figure out what their position is on allowing the tenants to have such uses. The situation may exist that perhaps landlords and HOAs already control that per their standards, and our existing standards for outdoor cultivation may in essence set standards to limit that type of use, but I think staff could probably share what they found in their survey, informal survey of properties. But before they share that, well, actually, I guess if you guys want to share your informal survey information on that.
Yes. We contacted every multifamily, either owner or manager, who had 6 or more units, and they were universally did not allow cultivation or smoking, I believe, in the units. So we felt that, given that they had pretty much occupied the field, so to speak, that we would need to take no further action in terms of regulating that.
But we haven't, I mean, that's one of the things that the commission needs to decide on.
That's correct.
Okay, and then we get to item number 5, which was allowing cannabis deliveries in town, including retailers located outside the town limits. Consensus from the PC to continue to allow such deliveries. I think at the last meeting, we noted that the Bureau of Cannabis Control set standards that are very comprehensive for these type of delivery uses, and we don't really think we need to adopt local standards at this time. 6 is really your key policy issue, which is allowing some form of non-medical cannabis retail and setting a limit on the number. It seemed like there's PC support for some form of non-medical cannabis retail in town. The question was really how many and what type. And so there wasn't consensus on this, and what we did is we summarized the Planning Commission's comments. And we thought the comments range from allowing only one business, which would be the existing medical marijuana dispensary, allow up to 2 businesses of any combination of retail uses, allow one of each type, which would be 1 adult use retail, 1 adult use delivery, 1 medical delivery only, or allow up to 3 businesses of any combination of retail uses, or allow up to 3 of each type of business, medical retail, adult use retail, delivery only. An example would be 1 business could actually represent 3 of those uses. But really, if you break this down, it really ranges from 1 to possibly up to 9. At least those were the general comments that we got from the Planning Commission. And really, what we thought as a suggestion to the Planning Commission is, rather than focus on what the specific number is, to start with, that maybe consider really focusing more on locational criteria. Because maybe the possibility exists, depending on what you agree, or the majority of you agree to on locational criteria, that may limit the number of possible locations. And if it limits the number of possible locations, maybe you can leave the actual number up to the council, but by setting those parameters, it's really gonna kind of bring down a number of possible locations anyway to start with. But that's the thought pattern, and what we thought is, if we look at the locational criteria, I know it's the Planning Commission, some had indicated if you maintain the state buffer zone is 600 feet from schools, daycares, or youth centers. We'll go over the map in a second. I think some comments we received was do not allow in the CL zone, that's a limited commercial zone. Do not allow in this, only allow in the CH, highway commercial, or CC zone, which is essential commercial zone. There was a discussion regarding allowing certain cannabis uses less than 600 feet from daycare type uses. Another was do not allow on Bolinas Road. Another was allow only in commercial areas along Sir Francis Drake, Bolinas, Broadway, and our Center Boulevard. You can kind of pick. Another was allow only on the 2nd floor or ground floor with non-street frontage. Do not allow in locations where youth congregate. Staff can also provide some informal surveys on that, or requires some type of on-site parking. And suggestion for these criteria is maybe the Planning Commission may do its kind of version of a straw poll as you go through locational criteria and see is there support for different ones of them. And you may find, depending on what the majority of you say, that you've created your own buffer zone in lieu of the state buffer zone, or you may want the state buffer zone with some additional criteria to make it further restrictive, and then you could tell from that really what could be the possible number of locations, and maybe setting a number is really you don't need to decide on, the council could decide on. So with that, because of that discussion, really number 7, where we had before, is where to allow. Really, that's a discussion you would take up with figuring out the locational criteria. This just has a slide that just says currently the CC and CH zones allow for general retail uses. CL zone currently only allows medical marijuana dispensaries, but not non-medical, so that would have to be a code change. And then the concept, I think, was raised if you want to add other land use restrictions, such as parks, to the buffer. And so, there we go. Okay, oops. Sorry. There we go. Okay, so this is the buffer zone map, and this shows youth centers and daycares and so on. But there was also a request at the last meeting, and then we revised this map to also include Deer Park Villa, which is down here. And you can see those are the CL zones that are outside the buffer zone, although this buffer zone slightly touches CL, and this is 10 Lima. And then we created the map without any of the buffers. This doesn't have Deer Park, but it has everything else. And then this is the map that shows with Deer Park Village. It actually shouldn't be red, it should be yellow, but you could see the CL zones in all the commercial areas in town. This is Bolinas and Sir Francis Drake and Broadway and Center right there. And then one of the items that the PC reached consensus on was to use the existing standards that we have for medical marijuana dispensaries as appropriate or if possible. We clearly would need modifications to reflect state law and allowing non-medical retailers if that's what the PC decides. We're suggesting we simplify the code for both medical and non-medical. Sort of like security delivery standards, we would just follow the state standards as opposed to imposing our own type of restrictions. And we had always suggested is really focusing on our local circumstances where the state regulations are silent. So formula businesses, parking, that type of thing. Now, I think one of the other decisions that we believe a consensus was raised by the Planning Commission last meeting is a majority of the PC supported a cannabis business permit process and a pre-application process. And so what that means is a business permit process is business specific. It runs with that business. So if it closes or is sold, that permit expires, the new business would have to apply. A use permit actually runs with the land, so that would always be there. In terms of pre-applications, it's the concept of setting a threshold in order to allow someone to apply for a business cannabis permit. We attached the staff report, gave you some information on San Rafael. Their process was they set a minimum threshold of 85 points. It got evaluated by staff. And if you reach the minimum threshold, you're allowed to continue on to the next process, which the next process, my interpretation of their next process is they had it ranked. And if they had more ranked applications than they did actual allowed licenses, then they did a lottery in order to see who can move forward. So we could do something like that, and then there's a question of should there be initial deadline for pre-applications, and that's under the concept we would be getting a bunch at the same time, being able to screen it, and then maybe you would choose the best of the best, or is it more of a first come, first serve? And then one of the things is some direction, should the cannabis business permit be approved by the Planning Commission or staff? San Rafael has it approved administratively. And then in terms of number 10, allowing existing medical marijuana dispensary to have a non-medical component. The council's request, the PCR reviewed and recommended, and the council actually approved the ordinance to allow the existing medical marijuana dispensary to do adult use delivery onlys. This would address really the issue of whether or not you wanted to allow an adult use, retail type use for an existing medical marijuana dispensary. But we're suggesting you don't have a separate discussion, but you consider that within your broader discussion. So for example, if you said maintain the state buffer zone, that applies to everybody, then the existing medical marijuana dispensary could not have a storefront, adult use storefront operation. It would have to locate that somewhere else or move its operation if it wanted to have it all at the same premise. And then in terms of tax revenue, PC agreed to defer this discussion until we actually knew what we're going to recommend to the council. And in terms of next steps, really as staff is based on your direction, if there's enough information there, you could ask us to prepare an ordinance. Then we would come back in January with the ordinance for your consideration. So that pretty much concludes the staff report, and staff here as well as the town attorney to answer any questions.
Thank you. Do any of the commissioners have questions of
Through
staff?
the chair, I do have one question in terms of the application process. I read and very much like the San Rafael process that they have adopted. I'm wondering, though, is there a time limit within which we must respond to a business permit application of this nature?
I'm sure with it, well, I think for something like this, we would create some type of timeline just for ourselves. I'm not sure what theirs is, but, it could.
I think they have a rather short, they have a definite date and a short response period. And so I was wondering if we could do a more expanded application receipt process and a more expanded review process rather than their shorter terms, if that was allowed. Thank you.
Any other questions for staff from the commission?
Yes, I have a question, and this might help clarify to our public the differences between the different permits. And we were talking about the business use permit, which is a business permit that would be handled administratively. Is that correct? Okay.
That's correct.
Okay. And then we're saying we don't necessarily want to apply a use permit because that runs with the land, correct? Is there a discretionary review process that is different, that the applicants would come before us so that we could know what they're planning to do?
If you wanted that, that's one of your decisions, whether you wanted the business process.
To include a discretionary review?
Right, to require the planning commission to approve the business permit.
Okay, because I personally would like to know what is coming online. I don't know if that's going to complicate matters for something that is maybe not an issue, but it just seems that this is such a new thing that it would be nice to know what is going up in our town, have, more awareness and involvement. The other question I had, and I'm not sure if this is too premature, regarding the micro businesses. So it seems like there are reasons why we can't do a micro business, because I guess there's a P component if we just wanted to do packaging and labeling, which under the micro business, it's an N permit, correct? Is that, so like an N includes a lot of different things, and that's not really something we want to do. If we wanted to create a process for micro business permits because we want to include packaging and labeling, it sounds like there is kind of a mechanism that won't let you just do that under the micro business. Is that correct?
Right. So under the proposed Bureau of Cannabis Control regulations, as we've discussed previously, a microbusiness has to engage in 3 of 4 activities: manufacturing, distribution, cultivation, and retail. And then the new proposed regulations that are expected to be approved in January state that specifically that sublicenses under the Department of Public Health or Department of Food and Agriculture, so the manufacturing and cultivation sublicense types, don't count towards the microbusiness license except for a type N license, which is for the infusions. Now, under the type N license, you can do packaging and labeling, but it would also include the infusions as well, obviously.
Okay, so I guess my question would be for building. I'm thinking about this, trying to compare it to like battery operated versus wired smoke detectors, where the state, has their own codes, and then they give local jurisdictions discretion to tailor the codes to either be more restrictive or relax them a little bit. Could that be considered where, okay, somebody gets a micro business permit, but then at the local level, we say, okay, under this micro business, we just limit, we just allow packaging and labeling?
So, I mean, it's not clear, but I think that could create problems when it comes to licensing, because the state licensing authority, the Bureau of Cannabis Control, is going to contact the town and say, does your local permit authorize this business to engage in type N infusions? And at that point, the town will have to say no. So I don't know how that process could really play out in a positive way for the applicants.
Okay. But so then would it follow that somebody could have, and I think we discussed this last time, and the answer is hopefully yes, that somebody could have a retail license and also have a packaging and labeling permit?
At a separate location.
There's a separate location or two separate permits,
They could have two separate licenses.
or, I'm sorry,
Right.
licenses.
But a
okay.
retail license does not allow packaging.
Right, but so that it's just the convenience of the micro business is so that you can do it under one application, one fee and everything, but it doesn't preclude a business owner to do packaging and labeling somewhere else.
Correct.
Okay.
A business can hold more than one license.
Okay, so I just wanted to confirm that. And then the third question, the last question is, has anybody looked at templates for pre-application processes or procedures with the BCC, the CDPH, and CDFA? Apparently, they have templates for pre-application processes, so.
I'm sorry, do you mean the applications people fill out to submit to the agencies?
No, I think there are, I would have to clarify, but I was just talking to the Office of Cannabis in San Francisco, and they were saying that there is, I mean, that they do have templates for the application, but I think they might actually have suggestions and templates that are for the pre-application process, and I don't know. So I was just wondering if anybody had researched that, or if that's something that could be researched.
We can research it. I just don't remember seeing that on the
Okay.
website. But you're talking about our own pre-application process.
Yes, but it's becoming so prevalent that I think there are templates out there
Yeah,
now.
either that or we would just use San Rafael's applications.
Right, okay, thanks.
I had a question, the conditional use permit versus the business license. Is there any reason why you couldn't have both of those in play?
I'm not sure why you would have both. If you had a use permit, then you're going to allow it. I'm not sure why we would also have a business permit process too. That'd be administrative, because if I don't know why we would decide anything different if the Plan Commission already weighed in on the topic.
Yes, and in fact, I would recommend against that because you're mixing something that runs with the land, i.e. is independent of a particular business, with something that's business-specific. If the commission wanted to have a hybrid approach that was business-specific, but, for example, preserved a discretionary review before the commission, we could work on that, and I think we could develop something.
Any other questions for staff from commissioners? I have a couple. So on the item number 8, which was about the modification of the existing standards for medical dispensaries to apply to non-medical uses, I think there's a slight disconnect, very nuanced disconnect between the slide that we saw, number 8, which has basically the question about rewriting our medical cannabis ordinance. But in the staff report, the gist that I took away was this was really addressing applying our medical standards to adult use uses, non-medical uses. So I think there's a little difference here, and I just want to make sure that the priorities that we're addressing, I appreciate the recommendation that we look to the state laws for adult use requirements. But I just want to make sure we are not overlooking the idea that we need to revise our own medical ordinance, and I didn't see that in the staff report, is my point.
Yeah, that'd be an oversight. Staff report, I'm looking at it right now, so we should have made that more clear. I think we should have made it more clear.
Okay, thanks. And then I also had some follow-up questions about the pre-application process, similar to, I think, some of the issues that other commissioners have already discussed. And maybe what I'll do is hold off on after we hear from the public about these issues. Before I open it up for public hearing, though, I just do want to say I see the logic of how we proceed in evaluating these questions a little differently than staff had recommended. And I really think we ought to be focusing first on the types and numbers of different uses, delivery, retail, adult use, and medical, before we start looking at the buffer zones and the locations, because I really want to tee up for this commission some analysis as to, I think for each different type of business that we're looking at, there may be different considerations in terms of location. So first, I want to really nail down the numbers of the different types of uses, and you pointed out there's a vast range of opinions on this commission, but I kind of want to start there and then go into location and then some of the other issues that we discussed, like parking and stuff like that. I just think the logical flow is for us to really figure out if we're going to, say something different about where delivery businesses can be located than what we're saying about where a retail business can be located. I think it's important that we first discuss which businesses and which uses and how we're going to address that before we get into the location, because we might have to have separate discussions about the location. And so I just want to say that. And now, unless anybody else has any other questions for staff, I think I'll open up the public hearing on this item, and anyone wishing to comment, please come up and turn the mic on and go ahead and introduce yourself and let us know if you're a resident of the town. And I'm going to limit folks to about 2 minutes tonight.
Hello, hi. Hi, my name is Olivia, and I'm 18 years old. I've grown up in Marin County my whole life. I'm here tonight to talk to you about
Olivia, can you back up a little?
Yeah, sorry. I'm here tonight to talk to you about the proposal for a cannabis retail storefront in Fairfax. 3 days ago, a survey came out from Monitoring the Futures. This survey indicated that vaping rates, specifically to nicotine, went from 11% to 20%. In Marin County, this rate is much higher. It went from 11% to 28%. These nicotine-based products are illegal for anyone under 21 in the state of California. But due to the easy accessibility of them, these products are widely used among youth. This past week, the California Healthy Kids Survey was released. This indicated an increase of marijuana consumption in the TAM Unified High School District from 2015 to 16 to 2017 to 18. Similar to juuling and nicotine, marijuana is illegal to people under 21, but it's still accessible. And the more product that there is within the community, the more accessible it will be to youth. As nicotine products such as Juuls are accessible in the county at places like gas stations or stores, youth, they have skyrocketed among high schoolers, and I have seen it personally. So if there are more storefronts and accessibility to weed in the county, the usage among youth will skyrocket as well, and it will rise dramatically. I want you all to think wisely before making any further decisions about opening the storefronts, and think about the youth in the county and the impact that it might have. Thank you for listening.
Thank you very much.
Hi, everyone. My name's Jazzy Garrity, and 52 Park Road, Fairfax. So I want to bring you back a day to yesterday, where one of the biggest deals happened in the U.S. Altria, which is Philip Morris, just bought 35% of the Juul product. That's nicotine-based products in the US. That was a $13 billion deal. Not only did they buy into the Juul market, but they also made, on the side of that, which was a little bit less popular and less noticed, a $1.8 billion investment into cannabis products in Canada. And they now own 45% of the Kronos company up in Canada. So they're back on the main stage. So this isn't small companies that we're talking about. This is big corporations owning a lot of the products that are going into the stores. So right here, I recently did a workshop on vaping, and I had a flyer. I gave it to you last time I was here. But I have another workshop coming up at Hall Middle School. And right here I have a couple of pictures just from that workshop of one product. This is a Juul. This is what a nicotine vaporizer looks like. And this right here, this is a Pax. So these products look exactly identical. One has an X on it and one has a dot. That's the only difference. And there are THC contents going into both. In marijuana consumption, I know that it was just mentioned earlier, but the rates have shown that contrary to what previously came out, a lot of people have been saying the marijuana rates nationally have gone down. In Marin County, they went up this past year. They went up from 42% to 46%. So that's actually a significant increase in Marin County. So that's definitely something to keep in mind with everything that's going on. I have some articles here I can give you. I know my time's up. And I'd love to share these with you as well, so I'll just give them over to you. And I'll give you the flyer for my vaping education night at Hall Middle School because the White Hill education night has already passed.
Thank you. Thank you very much.
Hello again. Deb Nelson, 37 Spruce Road. As the discussion continues, one very important element seems to have been left out, and that is of public safety and the impact to our police force. To this end, I've done some research and found two very informative web pages documents from the state of Colorado. The first I'd like to quote is titled, Colorado's Legalization of Marijuana and the Impact on Public Policy, Practical Guide for Law Enforcement. A few major notes. Banking systems are unavailable to the marijuana industry, which created a dangerous level of cash. Marijuana illegal trading through the black and gray markets did not decrease. People have overdosed on the higher levels of THC, leading to potential psychotic breaks, and youth use and addiction rates increased due to ease of accessibility. The second resource is a report from the Colorado Department of Public Safety, Division of Criminal Justice, Office of Research and Statistics. It's titled Impacts of Marijuana Legalization in Colorado, and it's very recent, October 2018. This report compares health and public safety statistics pre and post commercialization. The number of fatalities with cannabinoid only or cannabinoid in combination positive drivers increased 153%. The prevalence rates for marijuana use in the past 30 days increased 50% for young adults, those 18 to 25. Emergency department visits increased from 739 per 100,000 visits to 913 per 100,000 visits. And then the number of calls to poison control related to human exposure to marijuana increased from 45 to 222. Marin County already has high rates of adult binge drinking, drunk driving deaths, and drug overdose rates. Are we prepared for the traffic and the high increase in crime and DUIs? Initially, I supported 2 dispensaries, but now that I've learned more, I request that we limit to 1 and honor the 600-foot buffer zone. Thank you.
Thank you very much. Anyone else here from the public who wants to talk on this item? Okay, thank you. I'll close the public. Oh, one more.
I'll make it super fast. Hi, my name is Kelsey Fernandez, and I'm just here tonight as a parent. I have
a son at Drake and a daughter at White Hill and a daughter at Drake High School. And I know that the discussion is around, what the regulations are in the buffer zones and things like that, but I'm just, I'm here hoping that maybe you'll also consider not allowing a cannabis storefront in town. And I'm asking that just as a parent. I am worried about what that might bring. It would be, as it stands now, the only cannabis storefront in Marin County. And I worry about, what kind of driving, that could bring. There's a lot of data, I think, that you have it around the impaired driving by cannabis and the increase in that, and also mixing it with alcohol, and that they've seen that around outlets. And so I'm just concerned if this becomes a destination, what the safety, what the public health concerns are around that. And also if it's a destination, just it being a cash business in another jurisdiction. Recently, there was one of the chiefs of police talked about that concern about storefronts possibly becoming targets because they are cash businesses, and there has been data too about increased crime in adjacent areas around dispensaries. So again, I'm just here, as a parent looking out for my kids and for other people's kids, and I hope that you'll consider some of these things. I know you are. I appreciate, all of the time that you're taking into looking into this issue. Thank you very much.
Hey, thanks. Can you turn that mic off for me? Appreciate it. Okay, now I will, see nobody else, I will close the public hearing and bring it back for a discussion by the commission, and maybe try to focus the initial part of the discussion on, as I said before, and if any of you feel strongly that this is not the right way to go, maybe I'll begin by explaining a little bit more my rationale behind wanting to start with the number of businesses. So we had, as we said, a broad range listed here on the slide that Garrett has up, between allowing only one business, which is the existing dispensary, all the way down to the bottom, which was allowing up to 3 of each type of business: medical retail, adult use retail, and delivery. I think it's wrong to say delivery only, and the reason I say that is that last bullet there on that one, it was my perspective, which was any one business could seek any of the 3 or any combination of the 3 licenses, so that they could do retail, adult use retail, and delivery, adult use delivery, and it wouldn't at that point be delivery only. And the reason I was looking at it this way was, it occurred to me that folks on this commission had, a variety of different opinions about how many businesses we ought to have, but that there wasn't as much strong feeling about which businesses they should be. It sounded like some of the commissioners felt like, look, we just have to have a limited number of businesses. I don't care if it's delivery or retail or medical, but just limit it to the number of businesses. And I think that's reflected in the second bullet and the fourth bullet. So if we look at this in terms of how many licenses the town would be issuing, that might be the sort of the clearer way to evaluate it. And for me, the question of how many licenses we'd be issuing. So if we look at the second bullet and the fourth bullet, you're either dealing with 2 licenses, in my view, in the second bullet, or 3 licenses in the third bullet. But each of those licenses would allow any combination of the uses. So you're basically issuing a cannabis license. And within the umbrella of that license for that particular business, they can do any of those 3 things. I don't like that way of looking at it, because I think we ought to be giving people more flexibility and giving more businesses the opportunity. So for example, let's say we look at the fourth bullet, 3 businesses of any combination of retail uses. You'd be limited to issuing basically 3 cannabis licenses. What if all 3 of those businesses decided they were going to do delivery? None of them wanted to do retail, and none of them wanted to do medical. I mean, obviously this is hypothetical, but that's, now you've just got 3 delivery businesses, period. There's no retail, there's no opportunity for anybody else to come in and try to affect a retail or do retail, because you've already issued your total of 3 cannabis licenses. But because those particular businesses only wanted to do one of the 3 uses, now nobody's going to do the other 2. So if we go instead to the last bullet, and you had a separate license for medical and a separate license for adult use and a separate license for delivery, one business could apply for all 3 and basically tick 3 of the boxes, 1 for each use, off. Now you've got 2 licenses for each use remaining. But it doesn't have to be applied for, all 3 types of uses could be applied for by 3 different businesses. So I'll stop gabbing, but that's sort of the way I looked at it, and I'm just interested if other people have a response.
So before we get to that, have we then finished our discussion on cultivation? I'm just going with the easy stuff down to the hard stuff. So I'm not sure the outdoor cultivation, we had come to any decision, but I may have missed that.
No, I don't think we have, but I prefer to grapple with the hard stuff and then go to the easier stuff.
Okay. Then let me ask the question, with different licenses, there have to be different locations, so, correct? So that when we had our medical dispensary get retail delivery, that license was for a different location. Now that location for them with the state could have been the next suite over from where their current dispensary is located, but it had to be 2 distinct locations, correct?
For retail, you can sell both medical and adult use retail. That actually, the planning director and I looked recently at what licenses had been issued by the state, and the vast majority of them are combination adult use retail and medical retail at one facility. And I also should just know, you may already know this, but I just want to clarify that storefront retailers are permitted to do deliveries as well.
Right, but I thought when we were discussing the medical dispensary that we had, and I think their attorney had mentioned that, then what they were going to go for the retail, the recreational delivery license, that couldn't be from the same specific address as the dispensary. So they had to set up a separate location, even though it could be a suite, another suite in that same building, but it couldn't be from the same exact address. So I just wanted to clarify that.
I think maybe we're talking about the same thing, but in terms of, as I understand it, for delivery-only operation adult use, it could be in that same space, but it's got to be separated out so the public doesn't have access to wherever they do coordinate all the deliveries from or store that delivery product per se. I mean, the state has its guidelines, there's just no public access. There has to be a different door for business deliveries and so on.
So as I understand it, the answer to Cindy's question is no, it doesn't have to be a separate location. It can be operated out of one location. It just needs to be physically separated within that location, right?
I would think that's correct.
I
Okay, I'm not convinced of that yet, but going to the issue of the different licenses and your approach, I think we're looking at it, or I've been looking at it, because that'll get into, the buffers and the locations as really locations of businesses, so that if you look at allowing 2 retail and 1 delivery, for example, we're really thinking locations in town. I mean, separate locations is the way I've been looking at that.
But wouldn't, if you had one business apply for 3 different licenses, as we've already discussed, it would be a business-specific license. So that business could conduct that particular business from any location that was within the zone that had been identified as appropriate. I'm going to go to Commissioner Rodriguez.
So maybe just answering your question about what my position, I guess, just on these topics would be open up the ordinance regarding medical marijuana and reduce it down to 1 so that the existing one continues to operate with its retail delivery, have 1 additional retail storefront with delivery, but I would limit it in physical size, the building or the unit size, because I don't want to see a 20,000 square foot retail, and then no additional delivery beyond those 2 businesses doing delivery. So not a 3rd location set up just for delivery, but allowing in general deliveries from outside the community in.
So that's looking at it from a physical location, then you're approaching that, right?
A number.
Okay.
Through the chair. In Commissioner Rodriguez's idea of one medical cannabis, 1 adult delivery, and then additionally 1 retail storefront that also allows delivery, limiting the size of it. I like the size limit idea, and I'm wondering, is it possible to limit the ownership so that it is a local small business rather than Philip Morris?
Let me, the existing medical dispensary ordinance we have in the section on transferring permits does talk about local ownership, and it also talks about no monopolies, meaning not having more than 1 business owned by 1 individual. So our current medical dispensary ordinance does talk to that to some extent.
I like the idea of not allowing large tobacco corporations to come in.
I have a question about your example, Mimi, that you were saying, what if you have somebody, I think this is what you're saying, what if you have somebody that just wants to run a delivery service and doesn't necessarily have medical or adult use retail or adult use delivery? Would they need to have a physical address, location? They would. So, and that would be outside the buffer zone. So, but I'm just wondering how realistic that is, somebody to just have a delivery app. Maybe it is.
Well, I think it's more realistic if we don't allow retail, obviously, right?
Right.
But I think it's just important to allow the flexibility, and frankly, I see it more as encouraging small business and the mom and pop kind of homegrown, business model where, somebody with a smaller footprint, maybe, one of the things we have to do is figure out where the delivery businesses can be located. And I've really want to make sure that we think about where delivery businesses are appropriate separately from where we think about retail is appropriate. I don't want to link those two necessarily.
Through the chair, if I can interrupt your train of thought, I don't disagree with you, except that the problem I see with that is our current medical cannabis business that wants to do only delivery out of their current location, which is in the buffer and would not be allowed. A new delivery business would not be allowed in that zone.
But Norma, that's the very question that we're sitting here to try to answer. So, the issue, I think, is where do we want to recommend the town council allow them? So, for example, if some of us feel strongly that retail should be allowed where the current medical dispensary is located, we can express that in terms of the location questions. And that's why I really want to separate them, because I think some of the considerations about where a delivery location is located, which have already, for example, been reviewed by the town council when they allowed the current medical dispensary to operate an adult use delivery out of that location, that it's just a different set of questions as to where it might be appropriate to have retail versus where it might be appropriate to have a delivery business coming out of.
I agree, and my thinking at this point, might as well jump in, is that I agree with the delivery only license for our existing medical facility, but I would not want to see a retail storefront at that same location. I wouldn't.
Excuse me.
I wouldn't mind that same business having a retail location elsewhere, but not at the current location.
So I'm still of the mind that the way I look at this, and I'm looking at it kind of from a location aspect, is that my thoughts would be allowing 2 retail and 1 delivery only. And then we address where in our zones, and then also address buffer issues with those.
So would that involve basically indicating that there would be 2 retail licenses available from the town and 1 additional delivery-only license from the town, understanding that the 2 retail would include the adult use delivery as well? So that's what I'm hearing you say. Okay, good.
I'd like to actually just kind of talk about, we're just talking about numbers right now. Okay, so realistically, I don't think anybody's going to apply for medical because the reason we're seeing medical, combination medical adult use is because the medical people are now coming to retail. And as we've heard from Marin Alliance, medical is just going to get outdated or, it's just going to disappear. So I would say leave the existing medical license to retail. I think we're a small town. I'm thinking about other business types, other restaurant types, and I'm not sure we need 3 for Fairfax. But for delivery, I think it could be 3. And I think one business could hold a license for 3 of a kind. So that's my position on it. 1, leave the existing medical, 2 retail, and 3 delivery.
Okay.
So that's 2, just for it's 2 separate retail and 3 separate delivery. Knowing that
Yes.
retail can deliver as well.
Knowing yes, that retail can, yes. So you can have a medical, adult use, and delivery, and that would count for the 3. So theoretically, Marin Alliance could do all 3, but you would give the opportunity for somebody else to just do delivery.
I think it's the same as you, Cindy. She's not including so if the 2 retail, correct me if I'm wrong, Esther, but if the 2 retail businesses that had applied for licenses also chose to do adult use delivery because they can, those 2 retail licenses for adult use delivery would count towards the total of 3 delivery businesses that you're talking about, correct?
So from a standpoint of...
I think she's saying I'm wrong.
No. So what I'm saying is that I'm giving a business owner the opportunity to just do delivery. So the retail, the 2 retail could have their own delivery. So that would, take away 2 of the delivery, and you have 1 left, yes.
So that's the same as what Cindy had proposed. A little, I think, framed slightly differently,
Okay.
but the end result would be, I think, the same number of licenses.
Yes, okay, I thought Cindy, you were doing the opposite, that you just wanted 1 delivery.
Question for staff. If I'm recreational retail, do I need to get a state license for delivery, or is a part of my retail recreational storefront allows me to do delivery? So it's not a separate license.
But we could make it a separate license, couldn't we? Wait, I want to hear the answer to that question before we get to our next question.
We can do that if you like. It could possibly get really confusing, but I understand what you're saying. But we can do whatever you think you would recommend.
Okay, well, I'm not sure we're at the point of making a recommendation, but I just wanted to clarify for Cindy the question.
Through the chair, to follow up on that, isn't that exactly what we did with our existing medical cannabis? Because medical cannabis allows you to deliver, but they needed a license for recreational delivery. And so they have 2 licenses.
It's a little different because the existing dispensary predates anything, so they're operating under use permits for both delivery and medical cannabis retail. So it's a separate process we set up for adult use delivery only for them. So it's only 1 license they need from us. They might need more from the state, but they only needed the 1 from us.
All right, I'm going to try and move the discussion along because we've spent a great deal of time on this item and I want to get through the rest of our agenda. But I do want to just kind of get through this first issue a little bit more. I think we've heard on the numbers from Commissioner Rodriguez, from Commissioner Swift.
I'd like to clarify on the numbers. I think at this point I would like to see 1 of each. 1 recreational delivery, 1 medical cannabis, and 1 retail, not in a buffer zone with restricted size and corporate ownership restrictions.
And I'm still of the mind that, I'm only kind of recommending the limit of 3 because the town council, that seemed to be their top limit. I really personally don't think we should limit the numbers, but I will go with the maximum that the town would go for, so
Excuse me, could you clarify when you say 3, is that?
I'm about to.
Okay.
So what I would recommend the council consider would be separate business licenses for each particular type of use, and to the extent that a adult use retail store was opting to also engage in adult use delivery, that would count towards the 3 licenses for delivery, but you would have 3 separate licenses available. Adult use retail, adult use delivery, whether or not it's connected to retail, and medical. So let's go on to location, location, location. We've seen a number of different maps with various buffer zones, and I want to focus on each of these separately. I think Commissioner Fregosa has already indicated that with respect to retail, and maybe we'll start with the retail, you want to preserve the state buffer zones. Is that what I heard?
Yes.
And do any of the other commissioners have strong feelings for the purposes of retail businesses in town as to whether or not we should recommend that the council preserve the state buffer zones or not?
So as far as the state buffer zones, then what you're addressing is the state buffer zone, not only for school, but also daycare and youth center, okay? Okay. So I think as far as, and when we get into other aspects of this, like Norma said, there's going to be restrictions that I see or needs that I see as far as size of a location, parking requirement, those types of things I think will limit. Retail will also limit a delivery only, and delivery only, when I look at this, may have a different parking requirement than a storefront. So when I look at the buffers for these is as far as youth centers and daycare centers, I would not keep those buffers for a retail or a delivery. I think as far as daycare centers that we have, and I think we've got like 2 on here, I don't see the impact of a delivery-only business being within that buffer, and in a lot of cases when you look at the potential for where a retail only would be, I don't see the impact on a daycare center for a retail only, especially we also have bars and other businesses in town that are for 21 and above. So I would remove the daycare and the youth center buffers. As far as the school buffer, we already have the medical dispensary that is within that school buffer, so I would even want to change that school buffer so that the building that houses the medical dispensary, the entire facility, is outside that buffer, so move that buffer so that it doesn't include that office building.
Cindy, I'm going to interrupt you for a second because I want to make very clear that we're just talking about retail, brick and mortar right now, and I just want to clarify because you did talk a little bit about delivery, but now I want to clarify that you're talking about retail for this buffer at School Street?
I think the buffer, yes, and to include delivery. So both of those. And then as far as the zones, I would, thank you. I would allow the CH, the CC, and the CL zones.
All right. Anybody else want to talk about locations for retail brick and mortar?
Yes. Unfortunately, I disagree. I really think we need to observe the 600-foot buffer zone for the for children's school, preschool, and I would include parks. Our children only develop once, and I don't think we can afford to risk the future until we have more data. I would give Jazzy credit until we know more what the effects are on our youth. As a parent raising a child here in Fairfax, the only complaint I had about raising my daughter here was that there were not enough places for youth to gather and to socialize. And, they would go somewhere else. But I think we need to protect the wherever the children are congregating now, or like the youth baseball league. I think we really need to respect that. They were here first. We've only got one shot for these kids to develop properly, to be great citizens in the future that are going to take care of us. And I don't think the verdict is in on what this is going to do to their development, so I would like to observe the buffer zone and include parks in that. So,
Norma?
Say?
Oh, yeah, I'm sorry, you did.
I agree with the buffer zones.
And so I agree with Norma and Esther to preserve the buffer zone.
All right, and from my perspective, I disagree with the buffer zone. I, again, reiterate my strong feeling that it's absurd to allow a bar in the downtown, but not a retail cannabis store. I think that's, doesn't make any sense whatsoever. And so I am in favor of eliminating the buffer zone for retail brick and mortar in the CC and CH. I am on the fence about the CL. And that's where I stand on that one.
Can I bother you to point out the CC and CL, because you have a colorized map?
So I'm looking at the School Street is CL,
Okay, CL.
and Deer Park Villa is CL, and 10 Olima is CL, as far as I understand it.
And so you would allow retail there?
No, I said that I was in favor of eliminating the buffer zones for the CC and CH zones, and that I am on the fence with respect to the CL zones.
can I just add, let me add an opinion about the difference between alcohol and marijuana smoke. Speaking from personal experience, I mean, there are a lot of canaries out there. I'm one of them. And every time I go by a dispensary, cultivation center, and I am have personal experience with this, I get high. Okay, it affects me. I'm very sensitive, and I know I'm not alone in that effect. I may not, it may not be the full effect, but it does affect me. And I know personally, and I know other people who are affected just by walking through the odor, and that's why the state has written a lot of, I guess there's you have to provide a plan for odor mitigation for that specific reason. There are very sophisticated mechanical systems to deal with this, but it doesn't always work. And I can tell you right now, it's not working. So I think if, again, it's not the same, in my opinion. It's one thing to go and intentionally go in and have a drink. It's another thing to walk through a cloud of odor. So, and I think the kids could be exposed to it until we know further. the other thing is that we can always change this once we have more data, correct? Or no? So we can see what happens and, give our kids a chance. And then, like I said, they were here first. I'm sorry, but it's just like with nature. We give nature a lot of respect because nature was here first. And I think we can always change this. So but once you give something, it's really hard to take it away. And I would rather be cautious and err on the side of caution.
If I may follow up on that, there is a difference between our local bars and a new cannabis industry. The bars were here before any of us, probably. And I'm not so sure if we had another bar application that I would be amenable to a new bar in town. I think we have plenty of bars, and frankly, I think we have plenty of restaurants, as much as I love them all.
Well, again, I'm just going to completely and absolutely disagree. I'm much more torn apart by the chronic alcoholism of our youth and how many people close to me have literally died from alcoholism, and I really don't see people dying from being potheads. So to me, there is a huge difference, but it slides the opposite way than you guys are thinking. So, maybe I'm biased against alcohol the same way, you guys are a little trepidatious about the, cannabis. But I think we've got a broad range, and I think the staff has heard from us on a number of these issues. I would like to move on maybe in the next 10 minutes and talk about the next item on this particular issue still, which is some of the conditions that we might want to consider imposing in terms of the locations. Do we think, for example, that adding on-site parking requirements, which, as we pointed out, might naturally tend to limit some of the locations where businesses are appropriately located. So we've got the slide here in front of us of a number of different things that the staff wanted us to consider. Could we very quickly kind of run down each one of us and say which of those we would recommend, or does people have an opinion about these particular things? For example, I am intrigued by the idea that we would require some on-site parking, knowing that the traffic concerns in town are, a big issue for most of us. And how would we perceive allowing a business to come into the town while not causing us to all stand still with traffic issues?
So I'll tackle that one. So along with, I think parking and size of facility sort of go together. So when you look at our current medical dispensary ordinance, that limited the size of the building to 1,500 square feet, exclusive of bathrooms. The new veterinary in town next to Iron Springs, I think staff told me that space was about 1,800 square feet. So I was thinking as far as next to Iron Springs. So I was thinking, a need for limiting the size of the building to, and I don't know, staff would have a better sense of the size of, hopefully, locations in town or businesses in town, but, 2,000 feet or below, that's going to limit your amount of parking. The current medical dispensary ordinance has a parking requirement in it. 3 spaces for the first 500 square feet and 1 space for each additional 500 square feet. Staff, in their staff report, use the example of a restaurant, which was a little bit different than that.
1 space per
when
200.
when you go up. So I would definitely want parking requirement, off-site parking requirement. And the other question in my mind on that would be, because I'm not that familiar with a delivery-only service, what the differences might be if you had a delivery-only facility as far as on-site parking versus retail. So that's my thought on those two.
Would you like to go, Michelle?
Why not? Okay, so I've already stated my position on the state buffer. I guess I would just expand the thinking. I think the 2,000 square feet is a bit too big. I'd go down to 800 or 1,000. But given the information that was in here, I really think we should also limit things. I don't think we need to do micro business, and I don't think we need to do manufacturing anymore now that we've read the material that was given. I also think we should limit sleek packaging and no flavoring. I agree with everything else on here except for not allowing on Bolinas Avenue. I think except in downtown would be fine for me. So I guess I'd have to go back to this map and figure out where that is, but, and then I don't think allowing on the second floor anymore is important. I think the on-site parking, I think we'd have to address that as part of a delivery service. Like when you have delivery vehicles, you really need to have designated parking for those if they're part of a company. But if we're not requiring that other uses in the downtown area have designated parking, we just had a restaurant and they had no parking. I don't really frankly know how different this is from a restaurant. So I don't care about parking. I'm still concerned about us processing this through the business license process versus a use permit, which I do believe you can expire, indicate that it expires at closure or with a change of use, because I think that the teeth from which the case, well, I might be wrong, but a business license administrative process does not have the strength behind it for the government, I don't think, to have, it's not like land use law that a use permit has. So I'm still a little concerned about that process still, but that's it.
And let me just, going over that list, the other thing that I didn't address was the second floor requirement, and I don't see that as a requirement. I'm fine with first floor. And I think that makes it easier when you look at potentially some of the people that would be utilizing a retail facility.
Through the chair, actually, I agree with that, Cindy. And I'm the one who brought that up, and upon rethinking it, I agree that we should not have to limit to second floor and non-street frontage. And also, I have said I like the business license idea because I felt that had more controls in terms of expiration of that business. But if we could have the same controls with the use permit that does not literally run with the land if the business owner changes, then I would be fine considering a use permit. If it does not run with the land. The parking, I think that if we limit the square footage, I also believe 2,000 square feet is too big. I'm wondering if staff can give us a sense, if you have any sense of average size of our retail store fronts. Are they
In Fairfax.
in Fairfax?
No, you can tell just by walking around, though, that the width of those spaces
I
is
think they're like 25 to 50 feet wide at
some narrower,
most.
yes, but the depth varies considerably, so.
They do, but they have a lot of, the restrooms are in the back and the storage and patio stuff and garbage. So the front areas, I wouldn't think are much more than 1,000 square feet of usable retail space for your typically 25 to 50 foot wide shop.
I'm going to make a pitch regarding traffic and parking, and that is that if Fairfax is headed towards adult retail, recreational retail, it will likely be the first, well, definitely be the first, but likely be the only one in the county for some period of time. And as such, people in Marin who don't want to simply have it delivered, they want to see the product, will be traveling to see that. We have heard estimates from industry people saying that, and they didn't talk about size of the storefront, but because it's a concentrated product by its nature, and that the sales, the per sale amount is somewhere in the range of $50, maybe more, that you could be talking several $1 million worth of sales annually. And if you run the numbers backward, you're talking maybe 200 trips per day. So when you're talking about that type of traffic, you definitely have to do the traffic study, but it also says, what's going to happen during retail, and that's or during peak hours, Friday evening, for example. So, party time. So that's the concern, is that if we ignore with the one destination Marin, the parking and the traffic component, if that's something that your planning commission is comfortable with and the council decides, so be it. But, just be aware that that's likely to be something that would be noticeable.
Through the chair, thank you for your comment. I wasn't aware that we would be the first. I thought there were already other retail shops in Marin County. Okay, that being the case, then I feel much stronger about the parking and the size.
I have a question of staff. I hadn't heard that either. So what was the number on the retail sales estimate annually, and how does that compare to any other retailer that we have in the city, the town?
Well, the actual sales are confidential, so I don't have that amount, but I've heard figures saying that $2 to $5 million range. Per year? Yes.
And so do we have
per year.
Any other retailer in this town that does that?
I'm sure we do, but
we can't comment on sales tax. It's confidential. I would say if someone was doing $2 to $5 million in sales, they would be in our top 25 sales tax generators.
Okay, guys, I want to keep going. Commissioner Gonzalez-Parra.
Okay, so I'm not sure I clarified that. I think it should be, I think retail should be allowed in the CHCC and CL, but with the buffer zones. I do think we need to require parking, but I think that site constraints need to be a consideration. So I don't know if that would introduce a mechanism, a variance mechanism to allow, or if it would be administratively approved, but I think we do need to look at parking. I think we do need to look at traffic impacts. I'm also in agreement that there should be a limit on the square footage. I also think that there should be a limit on the revenue. I think right now our ordinance for medical has a limit on revenue, doesn't it? No?
Revenue?
You mean they can only make so much money?
No, well, let me just clarify. I think we need to look at it because we're talking about the cash and security issue until, I'm not sure why.
I mean, how much cash on hand? Is that what you mean?
I think that's what, it said something about that. What I was reading like a couple months ago, there was a limit. The state has had a limit before, and what we drafted actually reduced the limit to something for the medical.
I know during the state law, I think, talks about for delivery, the amount that of cash that can be in the delivery vehicle, but nothing about.
Okay, so that being said, I mean, because we don't want to limit the revenue for taxes, but I'm concerned about how we define how much cash is on location and the security issues, so I think that needs to be looked at. I mean, we don't have to say there's a limit of 1 million or 2 million. I'm just saying that we need to look at that in terms of how that money is handled on site because of security issues.
So maybe what would be useful would be to look at the state's regulations
Yeah.
as far as security and all their other regulations, and be familiar with them as they apply to a retail storefront, so you're familiar with that.
Right. My understanding is that they are cash only because it's still federally illegal, correct?
Drug dealers don't take checks.
Well,
Okay, so I want to keep moving us along.
and, okay, so we talked about square footage. I still think that it needs to go on the second story or somewhere that it doesn't have a storefront. We can always change it later, but I think that's a good place to start. That's where I feel comfortable.
Okay, and from my perspective, I like the idea of requiring on-site parking for both retail and, as we pointed out, delivery, to the extent that dedicated spots are going to be needed for vehicles that are performing the deliveries. I think that those requirements should be separate. Again, because I like the idea of having a separate license for retail and a separate license for delivery, so I think that these should be separate, and that way if somebody's doing both retail and delivery, they have to meet both sets of requirements. And that's another reason why I think we should allow a broader location for the businesses, because I think if you include buffer zones and parking restrictions, you're basically regulating it out of the town, and I don't necessarily want to do that. The size is, I could go along with that either way. I don't have a strong preference one way or the other about the size limitations, and I don't have an interest in limiting it to a particular floor, whether that be second or ground. And limiting it in locations where youth congregate. I think, as I indicated previously, I'm definitely in favor of keeping it in CC and CH, and I'm on the fence with CL. Okay, so I'm going to move on to cultivation, and we're going to spend 5 minutes on cultivation. Which means each of us gets to talk for a minute about cultivation.
I thought council had already ruled out cultivation. Wasn't that in one of our?
Well, personal cultivation, adult use. So the state allows up to 6 plants, whether indoor or outdoor, for personal cultivation, according to the information we got from staff. And so we had previously allowed a greater number of outdoor plants being cultivated, and we need to change that to get in line with state law. However, my understanding is that there are some details in terms of, balconies, multi-dwelling units, how we're going to address those. So maybe we can, we've got that slide up here.
Also, I was confused. It's commercial cannabis cultivation that the council did not agree.
Okay, so I can start. So as far as the outdoor restrictions, I think 6 plants. And then as far as multifamily, and that would also include duplexes. So I would still say 6 plants per site, or however we define that, because we had the discussion about what the state law says as far as lots and that type of thing. So I would say 6 plants outdoors per multifamily, per duplex, per
parcel? Are you speaking of a parcel?
Per parcel, okay? And in our medical marijuana cultivation, we had requirements in there that talked about 5 feet from a property line, rear and side yards only, not front yard, not visible from the public right-of-way, not to exceed over 7 feet in height, surrounded by a fence not more than 6 feet tall, and no netting or plastic screening, not on an unimproved lot. And then there was one there that said prohibited on parcels within 200 feet of any public, private, preschool, elementary, or middle school. So, I'm fine with those. The prohibition on parcels within 200 feet of a school or daycare, I'm either way on that. And then as far as balconies, I would say no.
Could a point of clarification, if we say that every duplex or multi-unit apartment building can have 6 plants inside or outside per parcel or per property, then does that preclude the owner from disallowing?
No, and we might want to have a specific provision that clarifies that.
Okay, Commissioner Rodriguez.
I agree with Cindy. I had just brought up at the last meeting, and so I'll bring up as an addition to that, just that it should be full-time residential occupancy. That should be the primary use, is the residential component. It shouldn't be rented residential properties being utilized for the cultivation of marijuana. Any structure that's built associated to this should be legally constructed. That means that the physical structure, the lighting, the plumbing, the electrical, because it's all energy and water intensive, has to be UBC. They've got to have consent of the property owner, and they've got to meet the noise ordinance, because they're probably going to have fans if they're doing indoor stuff. But I agree with Cindy.
Okay, so I'm actually really grateful that you guys did this survey, because it really gave me insight into what happens in multi-family complexes, and that was my concern. I think the 6 plants per property is fine. It seems that it's not really going to be a problem with multi-family units. However, I don't know if there is a way to put in, I don't know how I would define the limits for multi-family units, but I think that there does have to be more specific language to that. As far as balconies, I'm okay with balconies as long as they're screened. I'm thinking about apartments, though, where maybe they would not have 6 plants. But I'm thinking that screening might be enough visibility, because I think when people see pot, it creates certain behavior or prompts certain behavior. So everything else that Cindy and Commissioner Rodriguez said, I agree with.
I think I've opined on everything at this point.
Okay, from my perspective, I agree with the comments of the other commissioners about the full-time residential occupancy, the existing outdoor standards, the limits in terms of making sure all the indoor electrical and outdoors all to code as a requirement. I am personally in favor of allowing 6 indoor or outdoor per residence or per unit. I think individuals, especially where it's medical cultivation, are going to have a right to their full share under the state law of the plants they can cultivate. And I am not in favor of a buffer on parcels within, certain distance of schools or daycares. I'm not in favor of that at all. I think every resident of Fairfax should be allowed to have their up to 6 plants. I agree that we should have the outdoor screening, and I'm okay with the balconies.
But just to clarify on your comment, there is not a buffer for a private residential cultivation, right?
I thought that's what Commissioner Swift had indicated. Under our current cultivation ordinance, there was a 200-foot buffer. Oh my God, are we done?
You are, and I have a suggestion, which is we seem to have been moving towards as much of a consensus as this commission is likely to get for the last couple meetings. What staff would suggest is that we start working on code, and that where we don't really have a consensus yet, we'll just put brackets in and list the range and make sure that we explain the rationales and the divergence of opinions in. We'll take that back to your commission and then bring that, assuming that that language is acceptable, bring that to the council.
And then,
Well, I am not sure that that's how I wanted you to proceed, because I want this to go to the council as soon as possible. I feel an urgency to move forward with this, and so I'm wondering whether the other commissioners feel that we need to look at that language specifically, or let staff take it to the council in January.
well, I want it to come back here. I don't want the staff to draft it and take it to the council without it coming to us. And the other question that I had along those lines was, so you would be looking at the medical marijuana dispensaries ordinance that we have, because ideally what we're looking at, I think, and what staff has said, is that we would have one ordinance that would address everything, right? So that you would be looking at the existing medical one we have and seeing where those can come together into one ordinance?
I think that's something we'll look at. You know, most likely there would be one, although your cultivation right now for medical is in a separate section of the code.
Right.
That might stay. We just might make it,
Okay.
adult use medical. However, so there'd be several different sections to be amended.
To be reviewed and amended. So I would like to see it come back to us in a draft code before it goes to council.
How about the other commissioners?
I agree.
Okay, am I outnumbered? All right. Okay. Thank you. So let's take a little 5-minute break, limit us to a 5-minute break, and then we will come back for item 2 on our hearing. All right, I'm going to bring us back into meeting mode.
Let the minutes reflect our return.
Oh, yes. Commissioner Caroline has returned to join us for public hearing item number 2, which is 407 Cascade Drive, application 1821, and Director Berto has a report.
Yes, and in the interest of the extent of this night's agenda, I'm going to be brief if you have questions. The Planning Commission previously reviewed this at their November meeting. It was continued at that time with various concerns cited by the commission, and you can see those concerns listed in the draft minutes that's at the end of your agenda, which I'm sure you've had a chance to review. The fundamental issue revolved around the size of the structure. Looking at the comparison table, you can see that it's several hundred square feet larger than the average home size in the neighborhood, and indeed of all homes in the neighborhood, with the exception of the immediate next door neighbor to the west. So the commission continued the item at the request of the applicant to provide them with an opportunity to redesign the building. The applicants have very quickly turned this around with a redesign that essentially lowers the size of the structure by 200 square feet. They have also added additional articulation to the front of the building by basically creating a two-gable view from the street frontage. They've reduced the building in width, which is primarily how they achieved the size reduction. They've also reduced the size of the deck in the rear of the property. So staff didn't have a strong sense of what the commission wanted to do with the project and whether or not the 200 square foot reduction was adequate in the commission's view, and therefore staff has three recommendations in terms of actions. The first would be to approve the application, and I've included a resolution to that effect. Staff believes that there was at least one commissioner concerned about the visual impact to the single-story neighbor to the east, and therefore has included a condition that would jog the building back on that side. I believe this can be accomplished fairly readily, perhaps leaving the single-story, second-story plane intact where the stairway is located. Another option would be to further amend the project if the commission has a good idea of what changes they'd like, so direct it, and we'll make sure that it's clear what your commission wants. We can incorporate that as conditions of approval and make sure that those are captured in the subsequent changes to the plans when they go to a building permit. The third would be, insofar as these applicants are definitely looking to get some project approved, would be to provide direction to the applicant on further changes and continue the project. I don't think they would look to get a denial and appeal it to the town council. So those are the three options, and I'm prepared to answer any questions you may have.
So do commissioners have questions of staff? Commissioner Swift?
So just a clarification, page 2 of the staff report, the first paragraph under discussion. Second to the last sentence, it talks about the the 9-foot west side setback remains unchanged. I'm assuming that's referencing the east side?
Let me check the plans.
The west side was changed.
The west side is definitely where the additional setback.
So then that sentence, the 9-foot west side setback remains unchanged should be the east side, should reference the east side.
Let me just lean over to the applicants.
Yeah, because here's north then.
Yeah, so that's the east side for the 9-foot setback?
Yeah.
Okay. Okay, that's correct. Okay, so that's a mistaken statement in the staff report. It's 7.5 on the west side and 8.5 on the east with the current proposal.
And is that a difference, or?
I believe that the west side has shifted back an additional foot or 2 feet. Okay, so from 6 feet to 7.5.
Sorry.
That's on the west side, and on the
Correct.
east side, it has remained unchanged. Is that the case?
I believe it's also shifted an additional foot.
Thank you.
Okay, yeah, if perhaps for those questions, it might be best to direct those at the applicant. I apologize.
Because it's a little unclear from the plans.
Yeah, the original set it was hard to read the setbacks. This one, you can see it in the bubble towards the front of the house. They are calling out the current setback. They may highlight that when they discuss their project in their slideshow.
Okay, because that also then goes to the table with the side setbacks and all that.
Correct.
Other questions? I have a couple. On the table in the staff report, there are two addresses identified as 407 Cascade, but they have two different APN numbers. Is the one... Well, I can't understand how that would be correct if there's different APN numbers.
Yeah, we would have to get one of those street addresses is erroneous.
Okay.
It appears, given that one of those buildings, yeah, the 730 for the 407, that's the seventh item down where it's listing existing 730 square foot building. That's incorrect.
Okay, and then in the resolution, on page 2, the second paragraph under the whereas, it says, prior to issuance of the building permit for the project, the plans shall be amended as follows. And in the previous paragraph, there's a reference to the plans received December 7th. So I may be confused, but I would have thought that the December 7th plans included these changes. Am I wrong?
No, the revisions cited in condition number 2 would further reduce the plans beyond the December 7th. So the current building is 26 feet 9 inches. This would further reduce the maximum height of the building by an additional foot to 25 feet 9 inches.
That would be what you're saying is that would be a recommendation from staff beyond what the plans are that we have tonight. So it's not in the existing plans, it's what the staff would recommend be changed.
Well, and to further clarify, 2A would be a further change. B and C are more or less memorializing modifications that the applicants have already made to their
Correct.
landscape plan. So this is just making sure that we're saying that there should be a screening tree in the front yard. They have provided that, but this makes it a condition of approval.
They've provided that, but after the submittal of the December 7th plans, you're saying?
No, it's actually shown. They have a western redbud in the front yard. This is a change that they made from their prior one. But the challenge is if they show that on the landscape plan and it's not a condition of approval, that in theory they could remove that from the final landscape plan. So this would memorialize that change needs to remain. So A is a change from their plans. B and C are already shown on their plans.
And A is a change that you all are recommending and not one that they've agreed to, is that correct?
That's correct.
Other questions? Okay, I will open up the public hearing and ask the applicant to come on up. And first off, I'll ask if any of the commissioners have a question of the applicant before I ask the applicant if she has something.
And I'm sorry, you might have already answered this, I didn't hear it. Did the building move back away from the street? It's still where it used to be?
Yes. Yeah.
Okay, so it's the revisions make it look like, or it appears like it has stepped back, but the garage is where it was before.
Correct.
Okay.
It is coming from the back. It's been reduced in size from the back.
Okay, thank you.
And you will go over the changes to clarify for us. Thanks.
Ready? Okay. Happy holidays to everybody. My name is Allison Madden. I'm the owner-builder at the project 407 Cascade Drive. When I'm not working on this project, I'm a stay-at-home mom to 2 little kids, age 6 and 3. I'm here with my team, who is my husband, Sean, and our architect, Jason Alden. I wanted to take this time to thank you all for this public service you do. It's huge time commitment, and thank you for reviewing our project in detail. And thanks to Linda, who's helped guide me up until this point of getting the first draft in, and to Ben for helping guide the revisions. I want to point out that we are not spec builders. We're a family of 4 looking to build our life in Fairfax. We've already invested a lot of time, money, and energy in improving this property. Since the November hearing, we followed directions from the November staff report. We've listened to the commission commentary. We've had direct meetings with our neighbors. Before we start our presentation, I just want to state, it seems like we're kind of all looking at this a little bit, but our latest revisions are above and beyond what the staff report recommended in November. And we have found a few inconsistencies it seems that you all are looking at from the December staff report. There were 3 main items that we addressed from the November staff report. One was massing and articulation. The second was the height of the front portion of the building. And the last was the addition of a native tree, which we provided in the front yard. In the November staff report, it was recommended to reduce the front half of the building by 3 feet. It stated the back half was not considered to be problematic at 28.5 feet. We went ahead and dropped the front portion 4.5 feet over the garage and took the roof off the front porch, demassing and articulating the house. And for good measure, and to not be back here a 3rd time, we took the rest of the ridge line down 1 foot 9 inches. Our neighbor across the street, Peter Denisovich, wrote a letter in support, and he stated he was comfortable with the height of the project as we revised it. So in the current staff report calling for an additional reduction of a foot, we think this is just very inconsistent with what we were told and directed in the November staff report. The staff report also recommended placing a native tree in the front yard. We did. We also went ahead and substantially redesigned the landscape. So there was some inconsistency with a recommendation in the December report for a fruit tree based on the changes we've already made. Maybe we just don't really understand how that was outlined. So on one final item, there was no mention of the rear deck being an issue in the November staff report. We went and met with our neighbors, and we viewed our story poles from their eyes and their property, and we went ahead and brought the whole back end of the deck in by almost 4 feet and dropped it down a little bit. So our neighbor to our west, she wrote a letter of non-opposition and was aware of all these changes. The new design, it's just made more private on all sides, and it somewhat diminishes our own view. So we weren't sure why that was also brought up in the staff report in December. So I just want to say thank you again for your consideration of our project and the effort we've put forth. My husband's going to start the presentation and talk about the history of the project, of the site.
Yeah, so we'll be brief because we know everybody's been here a long time. These are the existing conditions. We just think it's important to note the history of the property and the existing conditions and what we've been through to get to the point that we're at now. Highlighted in blue is the approximate boundary of our lot. It's no mistake. The existing home did extend over the property line to the south. And then what you don't see is on the east side, highlighted in yellow, this is the neighboring property. It's about the same size, same shape. But yet, over the years, the existing home encroached on that property as well, taking 5 feet, as highlighted here. And then to the rear, this is 40 Meadow Way, and that property was substantially impacted as well by this home that existed. You can see it's clearly bigger than 700 feet. What existed was a 2-story home measuring 25 feet from peak to grade. It was 2 stories. The residence was comprised of 2,600 feet of living space, 1,800 feet of which was illegally constructed over a 30-year period. The property line disputes to the east and to the south side, 40 Meadow Way in 2013 was cited with a physical notice of violation by the county. And at the time, that property was in an estate, and the estate was in no position to handle it. So it put an enormous impact on those folks. You can see this creates a situation that's just not harmonious, and it disrupts the fabric of the community. It creates a negative impact and is disrespectful to the immediate neighbors, the neighborhood, the town staff. and the ecology of the area. It had additional accessory structures of approximately 200 feet. This gave the property an existing combined FAR of 0.44. It's important to note that's what existed. What we are proposing is an FAR of 0.35. That's approximately 25% less. It's less of an impact, and the home will be designed, not to mention with additional green building technologies, which further reduces the ecological impact on this site. This is the FAR table that's on page 4 of the staff report. It lists the FAR of the property. And we just want to point out that we understand the methodology used in this table. The data is harvested from the assessor database. However, the assessor database has limitations when it comes to accuracy with reflecting current conditions of properties as reflected. This is the correct APN number for 407 Cascade, which is our property. The FAR is not correct. It's approximately 4 times the size of that, but that's what happens with these assessor records over time. They become less accurate, as our property illustrates. Given that every square inch of our property, of our new project, will be considered in our FAR numerator, we just ask that the commission please consider FAR of our project relative to what truly exists on other properties in the neighborhood. We're proposing a standard home that's well within the guidelines established by the town and is consistent with the town's general plan of improving housing stock, and this is also done on an infill basis. Comparing us to assessor records such as this table doesn't necessarily provide a fair comparison on a relative basis. If a comparative FAR is to become an important factor here, we just ask the commission that more consideration be applied in determining the real FAR of what truly exists on other properties. And Allison's going to come back up here and talk about some of the pluses of our project, but I just want to reiterate that we took the existing home down because of existing life safety conditions, and not to mention the acrimony it created in the neighborhood. As such, we are currently construction in progress. We're not developing a vacant lot. And you know, we just want to point out that we think that the Cascade Canyon is one of the most beautiful places in Marin. And we look forward to continuing the rehabilitation of this property and giving the space the respect that it deserves.
Thank you. I am kind of interested in keeping our pace going,
Sure.
so if you could be very brief with any additional comments, I'd appreciate it.
Well, I will cut it short. We've been here since we purchased the property in 2017. My kids are here on a regular basis. You know, we've gotten to know the neighbors and the community, and we've all kind of marveled at what the neighborhood referred to as the beached whaler. And we took it down for a number of reasons. Just want to show this image of what it was. It was there's a support beam here, so being supported by stacked brick and wood shims. As we demoed the building, it revealed mattress box springs and weight benches and barbells that were used in place of rebar in the foundation. And the entire building was wrapped in Reynolds wrapped aluminum foil as weatherproofing under the siding. And there was drywall as subflooring in the basement, just placed on the raw earth.
I'm going to interrupt you because I really have a large agenda, and I'm focused more on the plans that are before us as opposed
Okay.
to what was there before.
Okay, so what we're proposing is a dramatic improvement, and that's what we're getting at. So it's consistent with the Fairfax Climate Action Plan, which was ahead of its time. It's going to be all to the strict 2019 codes of Title 24. Every system in this house, appliances, lighting, heating and cooling, all the controls for those systems are energy efficient. We're putting a solar array on the roof with room for expansion. We're not going to have a chimney. We'll have permeable surfaces, infiltration basin. We will no longer have a house that's dumping water directly into the creek. No off-haul, completely WUI compliant. A lot of our neighbors don't even know what WUI is. So we feel this is a dramatic improvement to the neighborhood. We already have a Ross Valley approved fire district vegetative management plan, and we're considering running our electricity underground as another safety measure. So Jason, our architect, is going to talk about the changes since November.
Okay, maybe 1 minute, Jason, because seriously, I have a long agenda here, and you guys have taken up a lot of space with something that, frankly, I think is not worthy of this much time tonight.
Could I add one more thing? I am appreciative that you're meeting the required UBC, but I'm more interested in hearing about how you have modified your original design to accommodate everyone's concerns, and in particular, what you have done to address your neighbor to the east.
Right. I'll do that very quickly. Here's the first floor plan showing in yellow at the top a narrowing of the width. So we took 1 foot out. That's the side that's facing the west, which is the 2-story house, and at the bottom of the plan is the east. On the upper floor, the 1 foot is also removed, but also this almost 3-foot pullback from the rear of the property. And that was basically the total of 200 square feet taken out of the house. And the major development on the rear is this terrace. The master deck is now 50% less in terms of usable space. That was an effort to kind of make it more private to the neighbors. And, because the neighboring property to the west also has a rear deck as well. And so we have, with the hedge and everything, we are really working towards that. So here's the front, street front elevation. And I highlighted this kind of smaller mast element in yellow just to kind of make it more prominent. This was the major shift. You can see the dashed line was the previous iteration. We reduced the mass, but one thing to keep in mind is I was constantly thinking of the design as a harmony, where just because we made a move in one area, it had to translate to the rest of the building. So that highlighted element, the roof line changed, so we took the ridge line down the whole building because of what we were trying to do up front. The symmetry of the windows and the garage doors, all of these things are in the details of the siding, the board and batten, and all the lamping. All that was done for consistency in the design. This is a view from the east. So this is from the 1-story neighbor looking. You can see in gray what the plan was previously and how the house was reduced down in the front, and in the rear, the second floor was pushed in. So this is a view from the street of the story poles as they are now. And what I did, I used this to map out the placement of the house. And then I took this and placed the 3D model onto that. So this is what the house looks like in context and in scale. And I think it's important to note the house to the west, which is the 2-story house. We are looking at that as well as the single story to the east. All of this is coming into play in our design. And the house to the west is at 27.6 ridge line, and ours is at 26.9. So we're actually lower in ridge, and then that forward height is at 25 feet. And again, the articulation in the front area will be narrowed. There'll be more planting in front and everything, but this was meant to show you as a diagram for proportion. In addition, we did some sun studies. This is this is June, showing how our house has very minimal impact for sun throughout the day in the summer months. And then the winter months were the worst case. And what I didn't do, I didn't model the trees or the ridge. I just wanted to point out the abstract nature of our building, how it had a minimal impact in shade to the 2-story house that we are closest to. And this is the rest of the month. So that's all I have here, but I just wanted to mention, so that your basic question about how are we addressing the neighbors. We shifted the house away from the 2-story house, so it was 6 foot, now it's 7.5, and we are 8.5 feet from the single-story house. There's no impact to the single-story house in terms of sun studies. All those, there's no shade impact on them, and the windows are minimal to that property. And there's all the existing landscaping. There's no really privacy issues that we were coming across. So we feel that design is consistent with Fairfax history, and basically that's the conclusion of our presentation.
Thank you very much. Any questions for the applicant or the architect?
I had a question. Looking at, and I know you changed your veg management plan, and in there you talk about that the attic and eave vents will be constructed to resist intrusion of flames and embers in the attic space, and you're in a WUI zone. and you're well aware of that. And one question I had for you is the venting on the building, be they, eave or, down below, is the type of screening that you would be looking to use there. You would be building in a recognized Firewise USA community, so you would be joining the Cascade Canyon Firewise USA recognized neighborhood. So a question that I had is, as far as the screening goes, would you be looking at 1/8 inch screening for your vents?
It'll be a slab on grade, so there's no crawl space venting, and then the attic is all conditioned. We have the insulation up on the attic portion in an effort so there's no venting in the attic. It's all part of the conditioned space. So that's, we won't have any need to have any screens for
So,
either
okay,
portion.
so the question that I had was if you had any kind of venting on the building that you would look to doing the 1/8.
Absolutely.
To prevent the embers.
Absolutely,
from
we
coming
would
in.
comply to that.
Right.
Any other questions?
I do. Just on the photo simulation, do you have one that we can scan left now to see the single story? Because this is a particular view.
Yes, and you can see I did highlight the two-story relationship, and no, I do not have in this presentation. But it is well concealed behind a layer of natural vegetation on the property line.
I have a question, perhaps more for Cindy than the applicant, given your Firewide Cascade program, Firewise program. I see some of the west side hedge is being removed. I believe that was a suggestion by the fire department. But there's a good section of hedge that remains at the front part of the property. Do you see that as an issue? It's very close to the property, a lot of green fuel for fires, but they are removing, well, they're only removing one section at the rear corner of the house, and the front hedge and the rear hedge remains.
If I could respond before Commissioner
Please.
Swift. I actually have had conversations with both the applicant and fire, and it was the staff person's opinion that that hedge provided valuable screening between the two neighbors, privacy screening, and in conversations with the fire inspector, the key element that occurred was to make that hedge discontinuous, and that's why there is that gap in the hedge. So I will allow that hedge is there at the direction or suggestion of staff. So if there's changes.
Thank you, that's helpful.
Any other questions for the applicant or the architect? Thank you very much. I'm going to have anyone else from the public who wishes to speak on this item, please come to the podium. And seeing none, I will close the public hearing on this item and bring it back to the commission. Comments, thoughts, questions? Commissioner Rodriguez.
So my position on the application has not changed. My recommendation would be denial. I don't think it's integrated into the neighborhood. I think it's too large in size, scale, and mass. It's over 1,100 square feet plus over the average and median sizes of the 14 homes that were provided as a reference in our charts. I think that was stated at the last meeting. To remove only 200 square feet is difficult. To review it again, I think the house overall is too large when you're looking at that two-story wall plane from the adjoining property. And I think the majority of the square footage is on the second floor. I think the presentation referencing existing conditions being at a 0.45 floor area ratio is a misrepresentation when the majority of that square footage was illegal construction. The use of staff using the county assessor data is the only data that we have available to us, so that's what we can do and rely upon. So I still think that this is too large.
Okay, so I appreciate, I wasn't here at the last meeting. I did watch the meeting. I've looked at the application from the last meeting, and I've looked at this, and I've looked at the changes that were made by the applicants, and I think the homeowners have addressed the visual and privacy impacts within their design. They've reduced the width and height of the building. The rear yard setback has been increased. They've articulated the front design. They've changed the back decks and reduced the depth of the second floor. I appreciate their efforts in making these changes to the house and to listen and work with their neighbors. So I would, and I think it's a better overall design and it fits better. I would, I'm happy with this design and I would look to approve it. The resolution requests, one of the items in the resolution was the suggestion that the maximum height should still be reduced by a foot to a maximum height of 25 feet, 9 inches, and I wouldn't see that as a requirement for this house. I think it's fine the way it is, and I appreciate the efforts of the applicants.
Other commissioners?
I would just agree that I very much appreciate the redesign of the facade. I think it's much better, integrates better into that community. I still think it's awfully high and massive on the eastern side where the single-family property is.
Okay. I also appreciate very much your effort to improve this. I did go by the site, and there was an improvement, and I did look at the property from the street and from Peter's deck. And I did it the last time, and I did it this time to compare. And so I appreciate it, but I wanted to see more. Here you had an opportunity to do a little bit more. I also spoke with a neighbor to the east who was very unhappy, and he said he was going to be here. He didn't make it, obviously. I felt his perspective on this would have been very important to hear. But I have to say, looking at this from the street, it was much better. I do appreciate the changes. Looking at it from Peter's deck, the house to the east looks dwarfed because of the massing on this. And I understand that you have a two-story next door. The examples that you provided of other buildings similar in massing in this neighborhood, one is stepped back really far back. The other one, I would never approve anything like that. The one that's right off of Meadow. So I can't approve it the way it is. I think staff's recommendations to step the east side of the second floor is a good idea. The other one is the second story rear facing deck. I think a 6-foot fence. All these meetings are archived, they're videotaped, so if there's any question about what the staff report says, you can always go back and look at the video to get clarification, because I think your neighbor was a little bit concerned about, the neighbor to the right, to the west, was concerned about visibility and sight lines. So it would be nice to see another 2 feet reduction either on, the whole thing or just the top. So I would recommend for modifications per staff's recommendation. And it looks like they are willing to continue this, so that's where I am.
So a question on that, the reference to the neighbor on the west, that was a neighbor that had submitted a letter of recommendation to approve the project?
Yes.
Correct, a letter of non-opposition.
I just want to say that I realize the applicants, they have a lot of, they've spent a lot of time and money involved in their new home. And I consider this an infill project on a previously developed lot that meets all the zoning regulations. And what they're doing is preferable to developing a vacant piece of property. I'm fine with the size of the home and the height. I do have some concerns about the landscaping plan. I found it hard to read because I had all of the Latin words. It didn't have, what the common names were and how high and how tall they were. So it was hard for me to judge what it was going to look like in the future. So so I would like to see that item come back, if we could add that as a condition of approval. Or, and then also, I don't think there's enough contrast in the color palette. The white might be too bright. I don't see any samples or anything, so that's another item I'd like more information about. But Commissioner Rodriguez's comments, I wanted to ask a question of staff. Where are we on the house size issue in town council? Is that item still going through?
The max house size, there was council consensus to reduce the maximum to 3,500 square feet. It is understood that that is not going to occur for several months, given the other priorities for work.
Okay, because I had, because it might be possible that, another thought that I had, and I think I've talked to staff about that, is in this particular case, they're 5% lower than what's allowed. They're at 35%. So maybe there's another way to look at if the commission has concerns that this house, they think it seems too large or whatever, with the neighboring homes, that maybe the FAR is another avenue that should be looked at, as well as maximum house size. So those are my comments.
Thank you, commissioners. I guess I tend to agree with Commissioner Fregoso. I appreciate the efforts the applicant has made to reduce the size of the garage, the height, the width, the west setback, the east setback, the rear setback, the depth, the rear deck size, and to increase the articulation. I am also in favor of requesting that the maximum height be reduced by 1 foot to a maximum height of 25 feet 9 inches. But other than that, I would be able to approve the application myself. I think that what I've heard is Commissioner Caroline would want to see the landscape plan come back. Commissioner Gonzalez-Parber would want to see the height plan, the plans with the reduced height come back. And I don't know how we move forward with kind of that variety of opinion, and probably need to to take a vote here on a motion, but I'm a little confused about whether or not we have the time to ask the applicant to come back again.
Every time there's a substantial change in the design of the project, it essentially restarts the clock. I think the applicants, and the question should be posed to them, if they would be willing to continue the item. Given the holidays, I'm not sure they're going to be able to turn something around for the Planning Commission meeting on January 17th, but maybe that question could be posed to them. Now, one question I had was when you were talking about agreement with Commissioner Fragoso, my understanding is that Commissioner Fragoso thought that it was too high and massive on the eastern side. So to the chair, were you talking about modifying the east side to reduce that?
Or maybe I misunderstood Commissioner Fragoso then. I am basically okay with the application as proposed, except for the maximum height as staff had recommended being reduced an additional foot.
Can I ask?
And could I just also, I thought I heard Commissioner Kierline also say she would like to see some alternative color palettes rather than just the white. I don't want that.
I would like, I mean, I don't have color samples been submitted for those? I don't seem, I'd like to see actual samples.
Yeah, we don't have those samples in front of us. We had them for the last meeting. My apologies.
Excuse me, I am still concerned about the relationship with the one-story house on the eastern side, and have not heard that there was any discussion with them about, I hear you do have agreement on the west side, and if it's coming back, I'd like to have that addressed with the adjacent property owner on the east, and at least get a sense of how they feel about that.
Yeah, why don't, I wanted to ask you about your willingness to, to bring it back once again to address some of the concerns we've heard from a couple of the commissioners about the landscape plan, the color palette, and the height, and the eastern articulation issues.
Okay, we have made 6 separate attempts to contact the neighbor to the east. I've left plans in his door, I've left shade studies in his door, I've left him handwritten letters, and he's just not contacted me. And I didn't want to contact him at work, I felt that was just too much. So I've tried to get feedback from him, and I haven't. It sounds like one of the commissioners has.
Yeah, I was there this afternoon. He just happened to be coming home from work, and we chatted, and he was very unhappy about the height issues. He was concerned about losing light and visibility, but he said he was going to come tonight and address his concerns.
Okay, but I made every effort to provide the information to him, and I heard nothing. So, I mean, I'm putting forth my best foot here. And yes, we would be willing to change the color. Yes, we would be willing to address any landscaping issues if you could make that more clear. I'm a horticulturist. I put the landscape plan together myself. So, I mean, this is my love. So everything, I've outlined it going forward, knowing that I'm going to have to review this with the Marin Municipal Water District. So I know their process of how they review the plant material, and I wanted to save some time for myself, so I put, maybe it was unclear for people who don't know that much about plants. So yes, I'm definitely willing to address those things. And if height is still an issue, I would have to talk to my architect to see where we could reduce it. So.
Question for staff regarding vegetation management plans. Do they normally come with Latin names or the common names?
If you talk to a botanist or horticulturist, they sneer at common names because, of course, they vary from area to area, but most of us know plants by their common names. So oftentimes they'll do both, and it's simple enough to modify their plans to do so.
Because I did take, because I looked at the requirement for the tree in the front, noticed that there was one on the plan, so had to look up the name, but I did get the red bud out of that in reference to that. But my other question would be is, bringing the height down. I guess a question for my commissioners is what does that accomplish for the commissioners?
Well, no, I think it opens up the sightlines and the light, the natural light to the east. I mean, it's not the applicant's fault that the neighbor has a small cottage-looking, building, but it's just a matter of trying to improve things. It doesn't have to be the height necessarily. I think it's just opening up the east a little bit. Just putting a little bit more of a buffer between this structure and the east. And, how that is done is really up to the architect. Just kind of break it up a little bit or soften it.
My concern is the applicants have come one time, and have taken, the comments from the meeting to heart, have gone back and made changes beyond what, I gathered from, the last meeting that they were asked to address. So if my fellow commissioners are not willing to vote on this or approve it, I would want to make sure that we're specific in our requests to the applicant for what they should look at to bring back.
And, I would have to say that they're almost there. You're almost there. I think the changes were appreciated. It definitely looked better from the street. I was even under the impression that the building had been pushed back because of the way you guys broke it up. It's just, I don't know how you can achieve that result to buffer a little bit more, and that's up to you, whether dropping it a foot would help, or if you want to set it back on the top floor, which I think is harder, to deal with the roofing and the angles and, all that. I understand you make one change and it trickles down throughout the whole building, and so I really appreciate the changes you made. They were, but it's up to you. One thing, either come down or 1 foot or, bring it in a little bit.
If I might interrupt a little bit, I think it's up to us to, if we have a majority that is feeling that we want to move closer towards approval of this, if there are some additional tweaks of the application, that it's up to us to be very precise. I agree with Commissioner Swift about what our expectations of the applicant would be if we expected them to come back again. So I am not as big a fan of sort of letting them decide at this point. I mean, obviously, I'm only one commissioner, but I just would want to be more precise and not risk them coming back and hearing us waffle again.
Okay, then in that case, I would just say drop it down a foot. I think that's what the staff recommendation was, or that was one of the suggestions. And the trees there.
Well, staff report was beyond a foot, so let's.
Yeah, I'm looking for that. Yeah, I thought it was more.
That the architect should get up here and speak a little bit about if we were asking you to reduce it by 500 square feet, how are you going to achieve that? Or, I don't think we're architects. I think you're asking us to do something when we're not looking at a whole set of information. We're looking at a view that doesn't show us.
Oh, they're asking for total. So they're asking for a total of 3.
I think he should be addressing this question.
Is there a recommendation for how we should proceed at this point?
I would recommend denial of the application.
My concerns could be addressed, I'm willing to approve it, and the items that I specifically requested could come back at another time. The landscaping, really, I didn't want to look up I have very limited time, I have a full-time job, I didn't want to look up all the Latin names, so it's helpful for me to have the common name and know how high it is.
And at the
so
last
that's why
meeting, I asked for that. I asked for a color palette.
Well-
I asked for changes to the color, so we're not seeing it on the second time around.
Well, I would, so that's my position.
Could you hold on just a second? Commissioner Gonzalez-Parber, could you turn your mic off? Okay, Commissioner Fregoso.
Okay. My major concern is that I also live in a small one-story cottage, and my adjacent neighbor built a one-story house, lovely construction, beautiful house, beautiful materials, and then several years later added a second story to that house, which has completely blocked out that entire quadrant of the sky for me. So I step right outside my house, and there's this massive 27, 28-foot sheer wall that blocks the sky, it blocks everything. And so that's what I'm imagining here, and that's my primary concern. Otherwise, I think your redesign of the front is very lovely.
Oh, sorry, I left my mic on after I told Commissioner Gonzalez-Parber to turn hers off. You know, I heard a recommendation from Commissioner Rodriguez. I did not hear anyone second that. Is there an other motion? Oh, no, I didn't. Does anyone want to second Commissioner Rodriguez's recommendation? All right. Is there anybody else who has a motion or recommendation at this point?
I would make a recommendation that we approve the project as it's presented this evening.
Is there a second for Commissioner Swift's recommendation? I don't hear a second of Commissioner Swift's recommendation. Is there another motion or recommendation from another commissioner?
Yes, I recommend that we ask the applicant to reduce the height by 1 foot at least. I think that would be the easiest solution. The 6-foot solid wall, I'm not sure if the neighbor is okay with the sight lines. I'm okay with that. The trees out there, I recommend that they come back with more information for the site plan, the landscaping, and color palette. Is that everything that and yes, we continue it, yes.
And is there a second for Commissioner Gonzalez-Parber's motion?
I'll second.
All right, we have a motion from Commissioner Gonzalez-Parber and a second.
I would suggest one thing. We were trying to find it, but somewhere in our code, and perhaps somebody in the audience knows this, if there is a tied vote, the project's denied. So I would suggest, in the interest of not getting hung on that particular aspect of our code, that we take a straw vote, and if it's going to go split, that we just continue the project if on a consensus basis.
We're moving to continue the project.
Right, but okay, that's fine. It's just that if we're split.
If it's because there's 6 of us, if it's a 3-3 vote, it gets denied. If it's a 4-2 vote,
But it's not a motion to approve or deny, it's a motion to continue. So if it's a 3-3 vote, then there would be another motion.
Okay.
So I'm going again to ask staff to take a vote. Call roll.
To continue. The motion is to continue the project with the adjustments we mentioned, which is a height adjustments. Yes, the height adjustment, yes, the landscaping, the color
boards.
palette.
And-
Yes, and talk to the neighbor.
Speak to the eastern neighbor to
Yeah.
get some.
And yes, I will figure out how to, we'll
If
figure that out.
possible, that may
If
be beyond their
possible,
control.
Yes. Yeah. Is that allowed?
Okay,
Can I broker
so,
it?
all right, I think we've got the motion and the second, and I'll have staff take roll.
Rodriguez?
No.
Swift? Yes. Fragoso?
Yes.
Gonzalez Parber?
Yes.
Kierline?
Yes.
Chair Newton?
Yes.
So I guess the question is, have we asked the applicant? Did we ask the applicant? if
I
they-
think we asked the
Okay.
applicant if they would be willing to continue it, so that is what we will do. And there's probably a form that staff is going to need the applicant to sign to agree or not?
If they've been exceptionally quick in turning things around. If they turn it around for the January meeting, no. But if it takes beyond that, I would probably ask them for a continuance.
Okay, thank you very
And I
much.
think it would be nice
Appreciate
to
it.
have that picture showing the adjacent lot.
Okay, thank you guys very much, and we're going to move right into our next item. No more breaks. No more breaks. So here we go with consideration of an ordinance of the town of Fairfax to consolidate titles 19 and 20 on telecommunications of the Fairfax Municipal Code into a revised Title 19. And Manager Toy.
Excuse me. So as you recall, you discussed this item on October 25th, and then you continued discussion to November 29th. And at your November 29th meeting, the Planning Commission actually provided staff feedback and comments and requested that staff return with a summary of those comments. Part of that process is the Planning Commission agreed that rather than doing specific changes to the ordinance that you received from the council, that you would provide general policy revisions for the council to consider. And so what we've done is we summarize the Planning Commission's comments and perhaps provide some clarification, because I know we gave you a lot of handouts, but we want to make sure that you know exactly what you would be approving this evening. So there's the resolution, and attached in the resolution itself, what we did was we added a couple of sections under the now therefore. So in section 3 of the now therefore, it says the Planning Commission hereby recommends that the Town Council strongly consider the Planning Commission's comments in attachment 2 and direct staff to revise the proposed ordinance in attachment 1 as the council deems appropriate prior to ordinance's adoption. And then section 4 recommends that after the council considers the ordinance and makes any changes, then they adopt an ordinance. So that being said, to your resolution, attachment 1 is the ordinance. Attachment 2 is a summary of the Planning Commission's comments from your November 29th meeting. That sheet, the comments, should have another attachment to it, should have 2 attachments to the Planning Commission's comments. One is the Burlington, Massachusetts recertification process, and the second one is a letter that was entitled Ordinance Recommendations, handed out to the Planning Commission on 11/29. I think it has 23 suggestions. So those are the 2 attachments that were attached to the PC comments that get attached to the resolution that would all go to the council. So I just wanted to make clear that that's the action you would be taking, that's what you choose to take. And in terms of the process, we'd indicated our goal would be, depending on the Planning Commission's actions, if you take action this evening, we would take those comments, the resolution, the comments to the council in its January 16th meeting. At that meeting, we would just be asking the council to review the Planning Commission's recommendations and direct staff as to what changes to the ordinance they'd like to see. Then based on that, staff report says February, most likely in March, we would take a revised ordinance to the council for consideration just because the time between the January 16th meeting and February 2nd council meeting, there may not be enough time to do all these ordinance changes. But that's, in essence, the process. So I think really the last thing is one of the key primary reasons for coming back to you, the Planning Commission requested that, is to make sure that we've adequately summarized your comments in that attachment. You may want to add more comments, that's fine, as long as we can make sure we get them correct this evening. That would be the goal, then to take it to the council in January. So with that, that concludes the staff report.
Thank you. Are there any questions for staff from the commission? Wow, okay. Hearing no questions from staff, we're going to open up the public hearing. Please introduce yourself and indicate whether you're a resident of Fairfax. I am limiting comments tonight to 2 minutes.
That's very, very exciting. My name is Andy Perry. I live at 10 Cypress Drive. Thank you, Mimi. I just wanted to talk briefly in my still 2 minutes, 1 minute and 59 seconds, about 19 and 20 again. And I did send an email to this effect. I guess a different way of articulating this that I am hoping will be included in the recommendations to the town council is I have the old chapter 19. It's 5 pages. In the old chapter 19, there are the following headings: purpose and intent, applicability, definitions, exceptions, Planning Commission approval required, findings, building official determination and need for building permits, timing, and appeals. Many of these sections refer to other sections in town law and other ordinance chapters. What we've been asking for the whole time is please to simply show us where the items in the existing Chapter 9 exist in the new 19. And I don't know if it's that terrible of a process. We've been asking for these 2 items to be separate, and staff apparently, Garrett and others, apparently don't want to do that. Legal staff, legal counsel doesn't want to do that. If they're not going to separate them, please show us and give us assurance, and I hope that everybody on this body agrees, and I hope that the town council agrees too, to show us that nothing here has been lost. Several attorneys we've spoken to think it's a daunting task to try to read the new 19 to see if everything here is in there. And so we're simply asking for that to be indicated as one of the recommendations to town council, to be assured that nothing in the old 19 has been lost if they are in fact going to maintain a consolidated version of that. Thank you very much. I have 15 seconds to go.
And so just
Thank you very much.
Point of clarification for, I guess I didn't understand what he was saying because okay.
Maybe I get this quick. So previously we have given a table that says section, old Title 19, section blank, new Title 19, section blank, and that table says which sections are incorporated into which. Now, if the comment is, did you take the language verbatim from the old 19 and put it into the new 19, I would say in general, no, but definitely for road access, the section, that language was taken verbatim out of the old 19 and put into the new 19. For landscaping, we put a note, and this was in the red line, that notes that we didn't use the same language because we believe the new 19 is broader and gives us more control. So to answer that question is, we did create that table. It was an attachment to previous reports. However, if the question is, did you do it verbatim, the answer would be no, other than for roadways. And so that would be a different discussion. But that being said, it's fair if the Planning Commission wants to point that out to the council again in your comments. That's fine. I just wanted to be clear, though.
Hi.
Hi. My name's John Snell, and I'm an electronics engineer with a background in signal analysis and transmission, as well as in biotechnology. I wanted to address the location and configuration of 5G. As your distance from a cell tower increases, the microwave transmitter in your cell phone increases its radiation power. The industry would like to place a 5G microwave transmitter and receiver called a cell every 200 feet, allowing your cell phone to communicate with that 5G cell with minimal microwave energy very close to your body. To reduce the amount of electromagnetic radiation from your cell phone, setback distance to a 5G cell must be reduced rather than increased. This may sound puzzling. However, in return for reducing distance setbacks, the configuration power of each cell microwave transmitter must be limited. FCC and the microwave industry set power according to a heating of biological tissue, not DNA damage. Although single-strand breaks in DNA chains often repair themselves, double-strand breaks in the DNA chain result in mutations which lead to cancer. Researchers at Columbia University have shown that double-strand breaks in the DNA chain are caused by cellular microwave energy. Because electromagnetic radiation is cumulative, exposure time must be limited. However, your smartphone communicates with the cell tower when you're not making a phone call and not texting. This stealth communication sends GPS information and other private information to the telecommunications industry so that you're constantly being radiated by the electromagnetic smog. 5G will radiate 24/7 at close proximity. As a result, the power or wattage of 5G microwave transmitters must be limited to less than the amount of power that causes double-strand breaks in DNA chains due to electromagnetic radiation accumulated over decades. Likewise for impacts on memory and attention, as determined by Dr. Henry Lai from the Biophysics Lab at University of Washington. Would it be okay to play music at 200 decibels 24/7? The loudness level of a pop concert is dependent on the broadcast power or wattage. Likewise, would it be okay to put a 10,000 watt lights on my car or store or house? Because government regulates such power levels, it can limit the 5G microwave transmission power configuration.
Can you wrap it up?
Yes. Because 5G cells will be all around us, close to us, and always on, so that your body is always accumulating electromagnetic radiation. Please set the microwave transmitter configuration so that the wattage power is limited. And you can reference the Environmental Health Trust document that I think Andrew Perry presented. Thank you.
Thank you.
Hi, Roberta Anthes, 2 Snowden, Fairfax. Thanks for hearing us tonight, and thanks for taking my papers. I also want to say thank you very much for your comments. I was so impressed, and they were excellent. I couldn't have wanted anything more. Thank you very much. And I will be utterly crushed if they go into our ordinance and go unprotected by our exceptions chapter. I think that's absolutely vital. Currently, and I just gave you our exceptions chapter, the old 19, and then San Anselmo's. Currently, our exceptions chapter is too nonspecific to be strong. Basically, it asks only that the applicant has the burden of proving that the exception should be granted. But what specifics are you asking for to prove that? I have looked through this. I did not see any language that defines what constitutes proof for the viability of a claim. There is general language, but not specific. This is vital in holding applicants accountable, and also in holding the reviewing authority accountable. You guys might be a great reviewing authority, but we don't know who's going to be here in 10 years. So I would like specifics in the ordinance that absolutely have to be met for an exception. If there are no specific conditions that have to be met, there's too much discretion on both sides, the telecoms and us. In the old Ordinance 19, the locations section doesn't say exceptions, but essentially are exceptions. We require, 1, proof that the preferred location was not available after good faith efforts were made to make it so. 2, an account of why the efforts were unsuccessful. Proof that the exception is essential for service, and Proof that no feasible alternative sites exist. This is pretty good. It comes from our old 19. It's not good enough. It only covers location. So we need something more than that, but we should not lose 19 because it refers back to 13. We need all those protections. San Anselmo goes further. It's still legal and it's not prohibitive, but it's responsible. It requires applicants to provide a clear objective. It covers exceptions to aspects other than just location, like design and noise and height, and demands reasons for non-compliance.
Can you wrap it up?
Yep. It calls for comparative analysis of why alternative locations or designs are not feasible. It allows for suggestions for alternatives. Applicants have to demonstrate why this exception is the least non-compliant option, and San Anselmo calls for a public hearing, which I think is vital in spite of shot clock. So please keep Ordinance 19 as it is and steal San Anselmo's exceptions chapter for a standalone 5G ordinance. Thank you.
Thank you.
I prepared for 3 minutes, so I will do my best. So, first of all, thank you so much for all of your recommendations and the effort you've made to incorporate them. And I'm actually going to start by also speaking about what so many have said, which is about Chapter 19. We have serious concerns about the combining of the two chapters. Why? Because, simply put, each lawyer we have spoken with has made it clear that this is a losing strategy. They've said it would be seriously tedious to try to incorporate all that was in the old 19 without losing what is important, and said they wouldn't do it themselves and cringed at the thought of trying to make sure nothing was lost. They recommended the simplest, most elegant approach being 2 standalone ordinances to using harmonizing language for any inconsistencies. We've been advised and agree that this is by far the best approach to protect the town and the contents of Chapter 19. So again, we ask the staff, why is combining them so important? And if we can take the approach of separating the two to ensure everything is covered, why not? You have heard from us a lot on this already, so we assume you understand, but look forward to presenting you with Chapter 19, the musical, with original score and choreography in the new year. Next, I'm going to talk about privacy and security. This is something we haven't brought to your attention before. We believe the question of how safe and secure 5G technology will be is of paramount, and it must be addressed in the ordinance specifically. We know that most wireless devices are much less secure than wired ones and can easily be hacked, even more so with 5G and the Internet of Things. I've sent all of you articles and information on this topic. Some of it's extremely disturbing, such as hackers who can access any smart device in a home within an hour, and threats of kidnapping already happening with these devices. You can check out the articles I sent for more. So we're asking for specific requirements in the ordinance to protect our privacy and security, something that requires the telecoms to guarantee that and prevent inappropriate collection of data or use of personal information. Otherwise, it's as if we're saying, hackers, come on in. So I've run out of time, but I just want to let you know we are presenting you with a document that has comments on the recommendations that you made, and someone else will be addressing that as well, and we hope you'll take a look at it. It's suggestions for how to improve the comments and the recommendations. Thank you.
Thank you, and that was Jess Lerner.
Through the chair, could I just ask folks, we have these fabulous new microphones, and you don't have to get up close and talk like this because it hurts my ears. Actually, you can sit back a good 10 inches and we can hear you even better. Thank you.
How's this? Okay. I was a middle school teacher, so I don't know how to be soft and sweet. Vicki Sievers, EMF Safety Network. I live in San Rafael. I'd simply like to share a couple of items from our San Rafael experience that relate to decisions here. First, the 1920 combine or separate dilemma. When several of us San Rafael residents first met with community development personnel in September to look at addressing small cells, the staff exhibited pride with regard to their municipal code adopted in 2004 and updated in 2014 to reflect new mandated shot clocks. One planner said, "Carriers know San Rafael as strict and stringent." It was clear that they saw their section 14.16.360 as sturdy overall and protective of residential neighborhoods, and we agreed for 2G, 3G, 4G, but we pointed out that small cells must be addressed. What was the ultimate solution? The city, in consultation with telecom law firm attorneys, same firm as San Anselmo, chose to keep its existing ordinance completely intact and not touch a word of it. They added a new section, .361, that acknowledges that small wireless facilities in the public right-of-way are unique and subject to additional provisions and standards, but then drafted a standalone document to address small cell equipment. On Monday night, 3 nights ago then, the council adopted that addition and another standalone measure setting forth policies, procedures, standards, limitations, and permitting requirements specifically for small wireless facilities. Second item, the council voted unanimously. They directed staff to look, in addition to that vote, with that vote, they directed staff to look right away at adding buffers around schools. They took seriously public comments recommending buffers around any place children learn and play, as well as healthcare and elder care facilities. 3 physicians were present, including 2 pediatricians who spoke about what they're seeing in their young patients, increases in debilitating neurological conditions like learning problems and ADHD, and more. One of them promised increases in childhood cancers and brain tumor increases without sufficient protection from 5G exposures. Please incorporate these important buffers in your ordinance. And last, to be sure that you are aware, you probably are, of the attention-getting letter to the FCC from Senator Richard Blumenthal and Congresswoman Anna Eshoo, asking for clear evidence of the safety of 5G. I have a few copies of that letter.
Thank you very much.
Richard Applebaum, 61 Woodland. I'd like to just quickly echo that I share the same views as my colleagues about retaining 13, 19, and creating a new 20. I've remarked on this at all the meetings previously. I would also like to echo Jessica's comments about the hacking and privacy. I think it's something new that we've all just been looking at, and I think that it's important. And so I'm hoping that you'll make some recommendations around those areas. The one thing that I wanted to emphasize tonight is about this issue about the monitoring. We're basically relying on the telecoms to sort of set their equipment up and then take their readings and tell us we're compliant with our own standards or whatever the regulations are from the FCC. And I'm absolutely sure that they have the technology skill and the budgets to create a 24-hour monitoring system. And I would really like to see us get into our recommendations, something of this regard, because I have zero confidence that the levels that we dispute are safe, that whatever they say is safe, that they'll even stay within those levels. And I don't think it's too much of a burden to have the telecoms. We live in an area where it's really easy to do 24-hour monitoring on technologies and stuff. So I would really like to see something like that get into the recommendations. Thank you.
Thank you very much.
Hi, Valerie Hood, Fairfax. My concerns involve fire risk, town liability for the unregulated poles that we have, lack of insurance, that 13 and 19 remained as standalones, the loss of property values near small cells, and the interface between town staff and realtors to make sure that this disclosure happens like it did with smart meters. And then I'd also like to know if staff has provided the Planning Commission and the Town Council with a written detailed summary of how they plan to manage the wireless facilities permit data once applications are received and processed. If the public is going to maintain any control over the conversation when the 5G train leaves the station in April 2019, we'll have to have access to the permit data 24/7. Local government needs to commit to working at the speed of the public, not just the speed of the FCC and the carriers. Shot clocks cut both ways. All of the small cell data can flow to one application for all jurisdictions and all processes via the Marin map. And I'm sure you probably know a lot about the Marin map, but all government agencies use the county's geographic information system, Marin map, to store and manage public assets like fire hydrants, public buildings, and street lights. Marin map is available to the public and seems like a natural fit for the situation, given it is already being used for street light maintenance. So we request that the Planning Commission make the recommendation to the council to direct town employees to use Marin map to house small cell data. If not, the data will reside on servers at the local government level where the jurisdictions can claim they have neither time, money, or staff to maintain the data. And I'd like our lawyer and town manager to please comment on this tonight. There could easily be terms, non-disclosure agreements, and proprietary clauses in the background documents the public will only discover well after the fact. This needs to be addressed. And we'd like the staff to answer the question, does Fairfax plan to use Marin map in their mix of business systems, if not as their primary data repository and mapping tool? Regardless, the public would appreciate a thorough written explanation of how and where the data will be stored, and more importantly, if the public will have access to whatever data the government has on demand 24/7. Thank you very much.
Thank you. Good evening. Go ahead.
Yeah, my name is Linda Hetzel, and I appreciate the opportunity to make some comments about some of the bullet points we received back from the staff, and to reiterate. The first one, require, and I believe you have these all now, require equipment owners of wireless communication facilities, WCF, to follow an annual recertification and affidavit process similar to the process adopted by Burlington, Massachusetts, which has been submitted. Number two, strengthen the wording "if feasible," in quotes, in the application process. Please remove the wording "if feasible" from the ordinance, therefore requiring undergrounding in undergrounding districts. Three, only allow in utility undergrounding districts, which requires equipment to be undergrounded. We ask that this item be moved up and highlighted, as it is one of the areas we are saying small cell equipment can go, but they must be undergrounded in underground districts. This, of course, does not apply to residential, where small cell equipment is prohibited. 4, concerns that consolidating the two titles into the new Title 19 may inadvertently omit key protection, as has been previously discussed. And therefore, we are requesting these two remain separate, using harmonizing language where needed to simplify the process and maintain these protections. 5, consider ordinance recommendations submitted by the local group. We ask the complete document we submitted, part of the public comment section of the staff report, be formally submitted as recommendations, and this be clearly articulated rather than just giving it mention as above. 6, beef up the exceptions provisions and pull together all exceptions into one exceptions section. We feel the language "beef up" is not specific enough. We made specific recommendations regarding exceptions and would like these details to be reviewed. We also further recommend using the language from San Anselmo's exceptions section, which is addressed further down this list. 7, consider adding the Town of San Anselmo exception standards. Please refer to this when looking at exceptions. 8, reduce the permit expiration period to less than 10 years. Please recommend to the council to create as short as possible interview for which permit will expire. A few years is more reasonable, we believe.
Okay, thank you. I'm going to
welcome.
cut you off here, and we've got
problem.
this all in writing, so I
Great.
appreciate it. Thank you.
Thank you very much.
Mallory Guidheim, Fairfax, Willow Avenue. I've been to a lot of these meetings, and except for maybe one or two people I've just heard, hardly anybody wants to do this. There's been a lot of educated people talking about the risks. I have read about the risks. I think they outweigh any benefit. 4 to 5 or 3 to 5 from a client of mine who's in telecommunications is not that different in speed. And what it is different in is the health of people who are going to be around the towers. And I just think I've really hardly ever heard anybody come out in favor of this. This is basically a pissing contest between AT&T and Verizon, and they want to have the sexiest number. And I think that's what we're all falling prey to. I don't think if anybody on this panel or in this room wants to have a cell tower, put it 10 to 15 feet from your house, if that's how you want to vote. I just don't think that the people who are very susceptible to it and who really have done a lot of homework, I don't think anybody wants it. I don't think it's going to be that much of a benefit for anything, and a lot of detriment. Thank you.
Thank you.
Hi, Kathleen Boggs, San Anselmo. Thank you for the tremendous work you've put into this. And I just want to drive home the point as far as keeping these away from schools and the kids. I noticed on the recommendations on the bullet require facilities to be a minimal distance from schools and daycares. I just think it's a typo. I think we want a lot of distance. So I think what was meant to say was minimum distance, and make it a big minimum. Thank you.
Thank you.
Good evening, Commissioners. Frank Ager, 13 Meadowway, here in Fairfax. There is historical significance as to how and why Chapter 13 in the 60s and Chapter 19 in the 90s were adopted. Chapter 13 is a code that that mandates underground utilities in a downtown area. Those chapters included exceptions that said Fairfax may approve an exception, not shall approve an exception if there's a conflict with state or federal laws. The night the Fairfax Town Council sent the proposed telecommunications ordinance to the Planning Commission, they said to keep Chapter 19 intact, a separate ordinance, and create a new standalone Chapter 20. That was the direction of the Town Council that night. This proposed consolidated ordinance is 1,260 lines long and is a blueprint for approving 5G small cell. Do not consolidate Chapters 19 and 20. Make the proposed telecommunications ordinance a separate 5G small cell standalone ordinance. Fire issues are real, and much of Fairfax is in the wildland urban interface zone, also known as WUI. Thank you very much.
Thank you. Frank, could you turn that mic off? Oh, unless there's somebody else coming up to talk. Sorry. Thank you.
I'm just going to be here for a minute. My name is Lauren. I live in Fairfax. I grew up here, and I'm very scared of 5G. Very scared. I'm afraid for the children. I'm afraid for fire activity. I'm afraid for what kind of things it emits into the atmosphere and coats over everything. I just feel like this is a big no. That's all I have to say. Thank you.
Could you turn the mic off for me? Thank you. And not seeing anyone else, I'm going to close the public hearing and bring it back to the commission for a rapid discussion.
I had a question for staff. Underground utility districts. So we have 6 of those. My understanding is that 3 of them by resolution allow for, I asked this question, allow for exceptions, including communication. So I guess my main question is, how do our underground utility districts fit into Title 19? I mean, how are they any different than an area of town that is not part of an underground utility district for this type of issue?
So I'm not an expert on looking at all this, but my understanding is our utility underground districts, there's 6. In essence, it's the commercial areas of town, which we had talked about, that's a possible location. My understanding is when it comes to these wireless communication facilities, the equipment, everything could try to be undergrounded, but in order for it to work, they still would have to have an antenna that would have to be above ground. So that's kind of the thing. And then for the other areas that aren't utility underground districts, then you get into the issue of if utilities are allowed above ground, can you make them just be underground when there's other utilities above ground? But
So within our 6 underground utility districts, then it can be required that everything other than, let's say, the antenna and the things that obviously don't work if they're not, if they're, can be underground. It can be mandated that
yeah,
in this environment.
Sure, I would say that was an argument that we would make. Whether or not we could do it or not, that's a different story.
Because my other, I guess, piece of that, and I'll get into my comments, is that we don't address in the draft changes, I don't believe there's any reference to those, that 13 or the underground utility districts. So just a thought there. But I can go ahead and go through my comments if you want me to do that and be done, or...
Yeah, if you could do it quickly.
That's going to be tough, but I'll try.
I would like to get through this tonight.
Yeah, it was. Yeah. Okay, so hopefully, town council will not only rely on, the staff report and the minutes, but hopefully they'll take the time to view all the planning commission meetings where we've discussed the issues and we've had the public speak, because what's in our staff report doesn't always cover the comments we made. So in looking at some of the ones that we had there, the discussion on the Planning Commission comments about the second bullet says recommending strengthening the word if feasible in the application process. So going through the draft, we talk about if feasible throughout the draft. Accessory equipment for roof-mounted facilities shall be installed inside the building to which it's mounted or underground if feasible. Regarding modifications, at the time of modification of a wireless telecommunication facility, existing equipment shall, to the extent feasible, be replaced with equipment that reduces visual, noise, and other impacts. Nowhere in there do we define what if feasible means, so I think the comment there about strengthening that was getting to more of a definition in some of the comments made by the community as to what that is. I could see a applicant coming in and potentially saying, well, it's not feasible because it's going to cost me more money to do it one way than it would be another way. So we're not really specific as to what that means to us. So that's where that comment was coming from. The fifth bullet requiring public noticing of eligible facility requests. This was referencing 1904-140 in the application process, because a lot of the applications I think that are going to be coming in are going to be of the type that fit under this versus potentially a new application, and those eligible facility requests are going to go to the zoning administrator for approval. So there isn't really any built-in public, as far as I'm aware, public meeting on that. So the comment on that would require that the applicants provide in a format that would be applicable for the town, some kind of public noticing as a part of that application. And as a minimum, we can put that on the website, or we can have some kind of a notice of eligible facility requests when they come in. The 8th bullet, requiring a physical map of the geographic service area in addition to the written description of the service area. In the draft, that was a reference to 1904-050A8. The establishing a time limit for the design and development standards extension, bullet number 9. This was in reference to 1904-140I5, build out plans for eligible facility requests, which allows the zoning administrator to approve one extension, but doesn't provide a maximum amount of time for which that zoning administrator can provide that extension. So I think that would be a consideration for the council to put a limit.
So are you providing the rationale behind some of these that you want to share with the council, or did you want to change actual wording?
I wanted to change the wording, and that was because the wording on the Planning Commission comments that were on here were just like bullet statements, and they didn't really explain. Some of them weren't specific as to the part of the draft that I was making comments on, and some of them didn't address the reasoning, which is in part why.
I'm sorry, I just wanted to be clear. So what you're reading are statements, is that something that you'd like us to take to incorporate into this?
I can provide you.
That would be the easiest.
Yeah, that's fine.
It's going to be really hard for us to write everything down.
And that's why I was that's the comment about having the council watch.
Some council members do watch the Planning Commission meetings, these items, so.
Yeah, I really appreciate that. I mean, it sounds like you're just saying you want a little bit more context to these bullets, right? Okay. Any other commissioners want to weigh in here?
I've been trying to get up to speed after being absent for a while, but I do have a few questions I have to read. I'm not quite. So is this packet, this is the recommendation to go on to council? We're going to vote on this. So a couple of questions. I have questions regarding 16 and height, and I think when I watched the video from the last meeting, I think Cindy raised some questions. Do we have any data? I mean, can we limit how high these antennas can be? I mean, in this wording, we have certain wording that says they can't exceed 2 feet above an existing utility pole. Another part, it says 7 feet above a light pole. I mean, can we put wording they can't exceed the height of these existing structures? Because I don't think we want to see these higher than structures that we already have. I don't know if it's possible.
So you're talking about
if they have to be installed at all. So anyway, that's a question I have, and I think there was a question raised if they can be prohibited on the downtown decorative light poles, and I didn't see that listed in here at all. And I was a little confused about the application process, because it talks that you needed to have a conditional use permit and design review, but then they talk about the zoning administrator, so it got a little, it was, so but that was, I didn't see that in the ordinance.
No, it's not in the ordinance.
So those were my comments.
Yeah, I mean, the idea was that staff was going to take the ordinance we reviewed at the last meeting and attach our comments as opposed to incorporate them in.
I have a question, just in terms of adding more restrictions. Are our
undergrounding districts seismically up to code? Or I don't know, I don't even know how you would define the underground districts. I mean, how do you,
Do you mean the polls?
no, the undergrounding, so maybe I need an explanation of, or a definition of undergrounding.
The undergrounding
For
utility
cables and
districts, right?
accessories, where everything goes on underground.
Yeah, it's just a vault they put
So
in the
it's just
ground.
a vault, so
In general.
it's not extensive, there is no opportunity there to say that they can't be installed where the structure is not seismically.
Oh, but it's usually in the ground or sidewalk or the
and-
right-of-way,
okay.
so I think it's, and they have
Yeah.
to meet it according to whatever utility
Okay,
standards are.
So it's not like people can walk down there?
Oh, no,
Yeah,
no.
okay. Wasn't sure, so we're just talking about like vaults. Okay, just wanted clarification on that.
Any other commissioners have comments on these recommendations?
My recommendations would be that I do think that we should have the two separate ordinances if there is some concern about lost information. Seems like we need to get some clarity about that. I would like to see more in the ordinance on the EMF sensitivities that are localized concerns, health concerns. I do think that the definition of modification of these systems should include software changes and upgrades. I think that the substantial changes should be reduced from the 20 feet. I agree with what she's saying, down to 2 feet, and include that substantial changes should include, yes, height changes, but also changes to noise, light, and EMF. I do agree that we should have land use buffers and more limitations on the zoning districts. I think that we should incorporate the San Anselmo exceptions. I agree with the preferences of I can't read my writing on that one. I like the idea of adding to the conditions of approval section the safety to our data and the annual recertification and the preference for undergrounding. And I like the recommendation for the reduced number of years for approval. And I also don't think that, I think we should really look at that CEQA issue a little bit more and whether we can have a substantial change section which is approving a variety of co-locations and additions without doing separate CEQA on those and how that relates to the ordinance. I think we need to look at that a little more. Thank you.
Thank you. Any other commissioners want to weigh in?
I agree with Commissioner Kirlin and Rodriguez's comment.
And I agree with much of what my fellow commissioners have already said. I think we've already included a recommendation that the council consider keeping the two titles separate. I agree with the looking at the San Anselmo exceptions. I also agree about limiting the maximum time for an extension. I think it's important to ensure that the application process be transparent and allow for individuals with particular sensitivities to participate in the decision-making and have their say as to whether or not any particular location would impact them. And then I also agree to change that bullet about requiring facilities to be a minimal distance from schools and daycare centers to say minimum. So those are my thoughts, and I think that's it.
I have just one more related to separating 19 and 20 or putting them together. If the town feels that they should be combined, I think what would be helpful for the next council meeting and would help the community is early on, there was that walkthrough between, that was done, and we haven't seen that. And I know at the last meeting, there was the discussion that we weren't sure that everything was captured. I think it would be helpful for the community to see a walkthrough between the old and the new.
You mean like the red line where we tried to note this was taken from old
Something that would be easy to read.
It's really hard
sort
to
of,
do that.
But to what you can do to walk through the old and new would be helpful for people to look at.
Okay, I think we're done with this item. So have you got all the feedback that you were looking for tonight?
We did get all your feedback, and so what would happen is we'll incorporate some of those I think that we didn't have specifically. It sounds like when you do your motion, Commissioner Swift actually had something in writing. If she wanted to give that to us, we'd be more than happy to incorporate her language right into your summary. That would be the easiest thing for us to do if the commission is fine with that. And then we have some of your other comments. We could beef this up, but if you were to make the motion, then you would just add something as comments to be amended as discussed.
And you also got Commissioner Rodriguez's comments? Okay. So I would entertain a motion from one of the commissioners to maybe approve the recommendations as amended based on the input from Commissioners Swift and Rodriguez and the rest of us as we spoke here this evening. I don't know. I don't want to put words in whoever moves his mouth.
Or her mouth. Question on the title of the resolution. The way it reads, it's a resolution of the Planning Commission recommending the town council adopt ordinance entitled, an ordinance of the town council consolidating Title 19 and 20 into a revised Title 19 telecommunications, blah, blah, blah. I guess even though it says within the body of the resolution that we want the council to consider our recommendations, it doesn't say that in the title of the resolution, and I don't know how.
Well, the title is
important that
referring to the ordinance that we haven't changed. So it's really referencing a document that's title was based on a previous iteration that doesn't address the additional recommendations that we're attaching. So the fact that it refers to a title that was sort of a snapshot of the title at a time, which is understood to be affected by our recommendations, I think is why that's the way it is.
Okay.
And there's clarification, and now therefores are the important part of the resolution.
Okay.
So, just wondering if any of the commissioners might want to bring forth a motion.
The only motion that I could make would be that this example be brought to the council for review and comment, that then be brought back to us with our revisions and their comments for a final review. The way that it's looking here, I don't know what I'd be sending to them. I don't think that this represents what we've been talking about, and that's what's making me a little nervous. I don't know if staff has any recommendations about.
So let's go back a little bit. So you may recall the council adopted, when this first came up, the issue of wireless telecommunication facilities, and we really didn't have any standards, and the FCC was going to make a ruling. Council adopted an urgency ordinance right away. And so, but with the urgency ordinance, which we modeled after Mill Valley's, that does require us to go back through the normal ordinance process. But we're also under this oddity where the council adopted this 30-page urgency ordinance, which in essence could be a regular ordinance, and took that ordinance and sent that to the Planning Commission for comments and questions. And sure, in your normal process, maybe it would have been everything would have gone to the Planning Commission a year ago and would have gone through the normal process. But this is a little different because you got something from the council, and we think it's at a stage where it's probably more effective or efficient, I should say, for the Planning Commission to almost play the role of the council, where you're going to share your general policy comments on the ordinance that the council adopted. And then the council, because they adopted that original ordinance, then could take your list of 30 or 40 policy suggestions and then direct staff on which ones we should incorporate. Then staff would go back, incorporate those revisions, take that back to the council for approval, and it wouldn't come back to the Planning Commission per se. So it's a little different in terms of like the normal process, but we think that's the most effective way in order to do this. If we did it the normal way, I think you'd be talking about this for a while, because it's just that complicated of an ordinance, and really it's one of those things where once we get direction for council how they proceed, then we actually could come up with something, and then the council could just adopt it. So that's why we've kind of recommended general policy discussion as opposed to verbatim changes to the ordinance. We think it's better that the council tell us what to do, and for all we know, they may adopt everything, in which case we revise all 30 pages or do whatever. So that's kind of where we're at. So that's why we're asking for something a little different. You're adopting a resolution that strongly recommends the council consider all your changes before they adopt the ordinance, then whatever they do would be okay. That's in essence what we're asking.
Through the chair, so you are saying it would not come back to the Planning Commission?
It would not come back to the Planning Commission, unless that's what you're going to recommend to the council.
Remind me, are we in a time crunch here? What are the time constraints we're working under?
So you need to take action to adopt a regular ordinance at some point for urgency ordinance. But in terms of the actual timing, my understanding is this. By January 14th, all communities need to adopt objective standards to deal with these small cell wireless telecommunication facilities. So we have that in place. We have an ordinance in place that governs the reasonableness, burden of proof, all that kind of stuff. Standards don't apply. Those things. So carriers have to comply. However, I believe in April, assuming there's not a court ruling that changes the FCC ruling, then in April, all the new standards apply in terms of reasonableness, if it's burdensome, and objective standards that are published in advance, something like that. But where we're at right now is the coalition we're part of has filed a stay, filed a motion of stay to stay the FCC's ruling, and that's in front of the 10th Circuit Court, which I guess they'll consider in January, 10th Circuit Court of Appeals. But so I think there's a rush in order to get a regular ordinance in place so that someone can't challenge you've taken so long.
By January 14th?
Well, just reasonably so the urgency ordinance can be replaced with this regular ordinance that has all these standards. Set aside whatever's enforceable based on what the court decides or whatever happens in April.
So would a possible recommendation be, we're actually adopting a resolution, aren't we?
Potentially.
Yes, you're adopting a resolution that suggests the council consider all your policy recommendations prior to them adopting a resolution.
Another option could be a continuance and asking for the package to come back with our content.
What they decide, right? Because they would have an option of,
No, she's saying before it goes up to
Oh, to come back to us before it goes to council with our content. But the timing is,
They have to adopt it and be effective by April. No, by April.
No, the urgency ordinance is in place. That satisfies the January 14th. Anything new you're going to want in your regular, then, that's in the regular, that could be adopted, that will replace your urgency ordinance. I think as staff, what we're recommending, and what the council would like, is that your comments go to them, they decide, they could just adopt an ordinance. You could always suggest to them that ordinance, that before they adopt it, they take it back to you, but you will have added 2 months easy to the process, easy.
And my concern is to have a continuance and expect staff to turn around this revision that incorporates our recommendations in time for us to rule on or look at it again in January and potentially get it to them in February seems like a significant burden on staff that I'm concerned they would have more time to do that if it went to council. I mean, I typically would not want to give council something this amorphous. I typically want us to craft actual language that we could give them. I think if I was a council, I'd be frustrated by seeing this not with a specific red line. At the same time, I am not sure that putting it off is going to be that much more efficient.
okay. Let me throw something out and we'll see, given what's going on. A motion to adopt Resolution 2018-18, recommending the town council adopt the ordinance entitled An Ordinance of the Town Council of the Town of Fairfax consolidating Title 19 and 20 into a revised Title 19, Telecommunications of the Fairfax Municipal Code, to establish uniform and comprehensive regulations for wireless communication facilities, and further recommending the town council strongly review and consider the Planning Commission's comments from our November meeting and also from our December 20 meeting, modifying and clarifying Commission's comments and directing staff to revise the proposed ordinance with all Commission's comments as the and send it to send to council for their discussion and consideration.
You really don't want them to send the revised ordinance, do you? I guess my question is, I thought we talked about how it's this ordinance with the attached recommendations that are revised,
With all our revised recommendations.
not revising this ordinance.
Okay.
Okay. And you'd also incorporate Commissioner Swift and Commissioner Rodriguez's comments on the recommendations attachment.
Not only on the recommendations attached to this staff report, but on the recommendations and clarifications provided this evening by Commissioner Rodriguez and Swift and Kierland.
So maybe, if I may, Madam Commissioner. So in the recommendation staff report, we have a recommendation, and I think I wrote down some of the key comments you said. So it'd be something like this. Adopt a resolution recommending Town Council A strongly review and consider the Planning Commission's comments from the 11/29 and 11/29 meeting and the 12/20 meeting, which offered modifying and clarifying comments to the Commission's comments. It should be worded better than that. And direct staff to revise the proposed ordinance as the council deems appropriate prior to the ordinance's adoption, and B, after the council's discussion, consideration, of Planning Commission's comments, adopt the ordinance and so on. So I've kind of taken a little of what you said, added in the two meetings, the comments from tonight, and so they have your 11/29 and you have your 12/20 comments all kind of wrapped together. So in essence, we took the minutes and whatever handouts that I think Commissioner Swift had, they would have a comprehensive package of what you wanted them to consider.
And then the issue of consolidating 19 and 20 that we don't necessarily agree with should also be under consideration.
It is
Okay.
a comment, but based on your comments this evening, you would end up saying it sounds like some felt strongly that should be the case. But I think the council will understand. I mean, they've been getting copies of a lot of this information. The public sends it to them. You get it, and I think they have a general idea of what they like to see done. It may not be everything that you would want, but I'd be surprised if it's not a lot of it.
Does the commission, just in a straw vote, would the commission, would we get a second and approval of that?
Hey, so
Of that
you've got
motion.
a motion, as you've discussed with town manager.
Okay.
Okay. Do we have a second of Commissioner Fregosa's motion?
Second.
Now, all in favor?
Can I just modify to say that I sent comprehensive comments to Ben and that that's what I'm asking to be included?
The ones that we responded to in email, there's a separate ones.
No, I didn't get a response.
Oh, was that the email where you clarified your comments?
It was going to each, it was like referencing sections in this code and saying recommend.
Oh, okay. I got this. Okay.
That would be a friendly amendment that I would accept to the motion to incorporate Commissioner Rodriguez's comments, written comments to staff.
And I will give you a written of what I said tonight, so you have that.
All right, so we have a motion for Goso, a second Swift, with the friendly amendment from Commissioner Rodriguez. And I am going to ask, all in favor?
Aye.
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 Any opposed? Unanimously passed.
Thank you very much. Appreciate all that effort of the Planning Commission.
All right, moving right along, it's still today's. So we are going on to the next item.
So they didn't pass the ordinance, they forwarded their comments on to the council. The council's the group. Mhm.
Okay, I'm going to keep the meeting going. Thank you very much for your comments, everybody, and thanks for coming out tonight. And I think the council will be taking this up next. So we are going to go move on to the next item on the agenda, which is 6 Fawn Ridge Road and...
Hey, excuse me, I have to recuse myself. I think I'm within the buffer zone.
Okay, well, hopefully this will go quickly and that you can come back when we're done with this one. Fawn Ridge Road, and we have Principal Planner Neal with her report.
Okay, this
But hold off until Commissioner Gonzalez-Parber is out of the room. All right.
Okay, this project encompasses the installation of a sliding glass door in the east wall of a second-floor accessory dwelling unit to access a new 924-square-foot roof deck. The deck railing will be of stainless steel tubing with steel cable system. The resulting appearance is very open, which will minimize the visual impact of the deck on neighboring properties and from houses across the valley and west of the site. The project site is visible from certain locations and from some houses and small sections of the public right-of-way across the valley from Fawn Ridge. The applicants originally submitted plans for a roof deck that was almost double the size of what they're proposing now. It covered the entire lower floor of the house. We advised the applicant that we could really see a portion of it. We had them put up story poles and mark it with orange tape. And in response to that, they pulled the deck back 12 feet from the edge of the house, which really minimized the impact of that deck on the neighboring house, which was the house we were the most concerned about. The site is located within the Ridgeline Scenic Corridor with the house sited on the top of the ridge. The house location predates the adoption of the Ridgeline Development Ordinance. Therefore, this deck addition requires the approval of a design review permit and a Ridgeline development permit. The proposed deck railings will not project more than 3.5 feet above the existing first floor roof line. And as we noted before, they've used a very open design, so the improvement will not substantially increase the overall mass or height of the building. The project is also not in conflict with the purpose of the Ridgeline Development Ordinance, which is to conserve the general public welfare by conserving the existing scenic resources and the sense of community and/or neighborhood identity now afforded by the presence of the unurbanized open spaces on the ridgetops above the town by preserving them in an open and scenically attractive manner. So, staff has included a recommended condition limiting the outdoor furniture to being of colors and materials that complement the surrounding natural environment and trees, and not to be garish or excessive in height or to project above the roof line of the second story. And we're recommending that you approve application 1822 by adopting resolution 2018-23, which sets forth the findings and the conditions for the project approval.
I have a question for staff, if I may. Linda, I'm confused with these drawings because I see a sketch of the fence that goes to the edge of that roof line.
It's just the materials.
Okay, so I don't know if that's just materials or if it in fact goes to the edge of the roof line.
So you should look at your, let me find out what page it's on. It does go to the edge of one side, but it doesn't project to the edge where the nearest neighbor is. They've pulled it back from that edge 12
And so
feet.
there's also this structure, what is that, a chimney? There's a structure in the
Yes.
center of that roof, well, that's
Right.
confusing me. So
look
the
at page-
fenced deck area goes beyond and around that structure as well?
Yes, look at page, if you look at page A42, 4.2.
I'm going there, A42.
If you see the measurement 12, so I guess the double line is signifying the new deck railing, and you'll see that the roof of the house projects out.
Projects another 12 feet.
Right, towards the neighbor that's closest to this
I got it,
property,
but-
to the deck.
But that fence does go from one end of the deck to the other.
Right, it's covering, yes.
And is that where the solar panels got removed in order to do this?
That's where they will be removed, yes.
Are they going to be replaced somewhere else?
You'll have to ask the applicant.
Okay, thank you.
Any other questions for staff?
And I bet he does.
Okay, I'm going to open the public hearing, and are you the applicant, sir?
Well, I'm Art Chartok. Rich Rushton, unfortunately, was unable to be here, And so I'm here to answer whatever questions I can.
Great, thank you. Do you want to ask your question of the applicant?
Yes, sir. You heard my question about the
Yes.
extent of the deck, which does go, I'm sorry, the extent of the fencing, which goes from one edge of the deck to the other and falls 12 feet before the outside edge of that
correct.
deck.
That's correct.
But
yes.
it does, the fenced area goes completely around that structure that's in the center, and the solar panels are being removed to accommodate this deck. Are they being replaced elsewhere?
I don't know that question. I really don't know.
Can we ask the
there
folks in
isn't
the audience to please go to the hallway to speak?
There isn't any plan that I know of to replace. Those are hot water collectors. They heat the water heater, basically, water heater.
I see. Okay, thank you.
So you probably don't know how the pool is being heated, or is it being heated? It doesn't have a solar heating system?
I think the pool has a separate heater,
Okay, but doesn't have like a...
not a solar heater, no.
Okay.
Any other questions for for Mr. Chertok? Okay, thank you. Anything else you want to tell us?
Not that I know of.
All right, I'm going to see if anyone else in the audience wants to comment on this application. And seeing none, I'm going to close the public hearing and bring it back to the commission and see if anyone has some thoughts.
So because the project site is on a sensitive location and can be seen from properties across the valley, my recommendation is that the steel tube railing and the vertical and horizontal railing be actually wood, that the steel cable systems be allowed, but that the railing be wood. Why is because this will be very visible. This will be shiny. This will be like a light. When you get
Excellent
sun on
point.
that, it's going to look like a light projecting backwards.
Yes, the glare will be tremendous.
Staff, can you address the visual impact? And because I know it was a question that I had in looking at the Ridgeline development ordinance, where it talks about significant view corridors and having the applicant address significant view corridors, and staff had gone out and looked at this, and that's why in the staff report there was oak was identified in addition to Toyon. So can you kind of...
I'm not exactly sure what you're asking, but I'll try to repeat what I said to you earlier.
That would be
This
good.
ordinance is kind of vague, you know? It talks about the intent of the ordinance is to try to preserve the ridge lines from areas of gathering places for the town. But there's no definition of what those are. All I can tell you is that in the years I've been here, they have typically been like the ball field, the parkade, you know, the downtown area. I cannot even think of a situation. We had one new house that was proposed where they determined that Bolinas Road outside of town was a significant area where you could look at this one site. That was for a whole new house. Then it has language that says if the Planning Commission determines that something is a significant view corridor, you have the ability to make that determination. I believe the intent is that if someone's going to build something that a lot of people are going to be affected by, that's a significant view corridor. I almost regret walking around to see to figure out whether I could see this deck, because I could see it from maybe 2 locations on Oak Road, and it was only if I like stepped completely off the road, you know, and peered between branches. But that was when it was out at the edge of the house. I believe it's been pulled back, and I think it's really going to be hard for anyone to be impacted by it unless they were on their deck and had binoculars. Is my opinion, but the code gives you guys the authority, if you don't agree with that, or if a neighbor shows up and gives you some kind of evidence that this deck is really going to significantly impact them, you can determine that it affects a significant view corridor. The problem with Fawn Ridge is all these houses predated the ridgeline ordinance, and a lot of them are plunked right on top of the ridgeline. And so, you know, if you really want no changes to, you know, if the intent is, I don't believe the intent was for that people that already have houses in the ridgeline to never be able to do anything to them. But I could be wrong, because I wasn't here when they adopted it in 1973. Does that help or make it more confusing?
Thank you.
Yeah.
And I think that my point is not that people cannot do anything with their property.
think
My
it's gonna be
point is that the
reflective.
selection of building materials must represent a rural area.
Yes, no, I agree with Commissioner Rodriguez. And I found those photographs that I had seen on page A1-1 that you took, Linda. And so clearly the building itself does not stand out, but the railing, I think we would see it shining from a distance. But this brings up another question for me. In this first photograph showing the solar panels, and that rooftop actually angles. This is, I believe, a question for you, sir. I'm looking
Except we already closed the public hearing.
Oh, but I can't ask him a question? Okay. Oh, they're leveling this roof that is shown as an angle?
Yes, they're gonna build it up so that it's level. It's gonna be a 2-stepped deck, right? But in the portions where they're gonna have to build on top of the roof and create a level surface. But it is a two-tiered deck. You step down from one portion to the other. But there is going to have to be some modification of the existing roof because
that
it's
wasn't
sloped.
clear. And then my other question, again, looking at this, if you remember, the deck at one side does not go all the way out to the edge of the roof. Which side is it? I can't tell now that it stays 12 feet back from.
So the very first photo, it is not going to project out to that edge. It's
Okay.
going to be set 12 feet back from there.
Okay, but it does go from one side to the other.
Right,
And
there's
that
no
will be
houses.
leveled.
There's no houses to either of those sides where it's there's a road, there's Fawn Ridge in between the one side, and then there's a big steep drop off to Bolinas Road.
Okay,
on the
and
other
this
side.
wooden trellis remains in place?
I really don't know.
Okay. So actually, yes, with Commissioner Rodriguez's modification, I'm fine with this.
Could I interject something? Perhaps a compromise solution to the stainless steel versus wood might be to direct either anodization, paint, or there's a variety of surface treatments that you can apply to stainless steel, a matte surface treatment, or wood cladding. I'm just concerned that this is a particular design. I agree, I think that the stainless steel, especially if they go out there and use the stainless steel polish on it, could be reflective in certain lighting situations, but I think there are surface treatments that could be directed, required with the applicant coming back, that would take it down to a matte finish. And then even though it's an unusual finish, it's not going to shine like the untreated stainless would.
I still think the wood would be a better complement to the rest of the design.
Unfortunately, I have closed the public hearing, so I'm not going to be able to. But I am not listening. This is the commission talking to the staff. So I'm sorry. I know it's formulistic, but I'm just trying to follow the rules. All right. So.
Well, I don't think the applicant's going to have a problem if you want different materials. They want their deck, but they always have the right to appeal if they're unhappy with the change in materials.
Well, and if we modify the proposal to allow for a variety of options such that Director Berto has referenced, either a different material or something to ensure that the reflective nature of the material is not as significant.
But the reflection is one thing, and the rest of the building, though, is wood clad, wood siding, wood trim.
I guess my concern, though, is what I heard, this design has been submitted with this material, and that are we suggesting completely different material, which would necessitate a different design?
Let the architects.
I like the modern design. I think that that's what they were trying to propose. And before Ben mentioned the color, I was going to suggest that that's another way, is that sometimes a dark color using black or maybe dark bronze or something like that helps that makes something disappear, or the non-reflective nature. So it could be possible, I think what Mimi was trying to suggest, that the applicants could maybe work with staff to find a
non-reflective material.
Non-reflective material.
I can live with that.
Staff be?
It's unfortunate that Rich, the architect, isn't here, but if you look at the street view, it almost looks like they were going to paint it gray to match the house siding. If you look at the lower right-hand drawing, that's what it will look. That's what it's supposed to look like when they're finished. It shows the 2 new parking spaces with the retaining wall, and you'll see that the railing going up to the 2nd floor and the railing on the deck appear to be gray to me. And I don't know if that would do it for you guys, or do you want to just say black? Or?
And I would just say that I think the wood post would make it look too heavy.
Chunky.
I think that's what the design, it's one thing that I think that the staff report alluded to the fact that, it is going to be very transparent, and they're not going to have a lot of privacy, but I guess the homeowner would be aware of that and the choice of the material, and that's.
I'm okay as long as it's not reflective.
I am as well. So I guess I should move. I would move to approve application 18-22, which is resolution 2018-23, with condition 3, well, wait a minute, that's not a condition. With condition 1 being modified to allow staff discretion on plan A7, does that work? A7. A6.1, let me see. I think A6.1 regarding the railing color to be non-reflective at the director's discretion.
Could you clarify exactly, is there a paragraph number that you're adding that to?
I'm modifying page 2. After whereas is the conditions of approval, which is approving the plan set, item number 1. And I'm modifying one of those pages because on the elevations, they're identifying material for the railing. And I'm saying that, but unfortunately, he didn't call out the railing here, so.
Are you looking at this page?
Well, I guess, you know what, I'm not going to even refer to the plans. I'm just going to say, adding to condition number 1, that the railing shall not, on the deck, shall not be reflective, and that it's up to the director to either add non-reflective material or change it to wood or whatever works for his discretion.
I will second that, sorry.
I think I don't want to throw the wood in there because that changes the design. I would ask that it just state that they work with town to come up with something that's non-reflective. With the existing design and materials.
I think it's gonna be pretty simple.
Yeah.
I don't think you need to reference the existing design or materials. I think you let the town manager and the applicant figure it out.
The planning
director.
Shall not be reflective.
Okay, there's a
So-
motion and a second?
Yes, we have a motion Rodriguez and a second Fregoso with the minor friendly amendment, that Commissioner Swift and Newton, if that's acceptable? No? What are you thinking about there, over there?
I think that the building is wood, and I think that wood would be fine, that they would color it a gray even if they added wood. But I think they are excelled enough to be able to decide to do it.
So you leave it open and let them figure it out?
Yeah. So I'm declining the friendly amendment.
Well, the friendly amendment that I'm offering is not to specify whether they continue with the existing design or metal, but allow the director, in his discretion.
I'm good with that amendment.
Okay.
And it's an excellent architect, so
Yeah.
I don't have concerns about them coming up with a good design.
That sounds good.
So,
Okay, so with a motion and second as modified, all in favor?
Aye.
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 Any opposed? Unanimous.
And one final comment, I very much appreciate the dark sky downlights.
There is a 10-day appeal period and a $500 fee for filing an appeal, and if no appeal is filed, the applicant will be good to go. Thank you very much.
Can we take a break?
Can we take a quick?
Okay, yeah, you can have about 30 seconds. All righty then, everybody. Now the really fun part of the evening.
I couldn't even read through this whole.
No, this is the fun part of the evening, Norma. We are going to hear from the planning director about plan development district zoning amendments incorporating objective development standards and procedures.
Thank you, Madam Chair, members of the commission. Yes, as we approach the witching hour, the fun part of the evening, and I will have a recommendation that may lower the length of review tonight. Brief background, what's driving all this consideration is the state has passed legislation, Senate Bill 35 and the Housing Accountability Act. And the purpose of that stated right there in the legislation is to meaningfully and effectively curb the capability of local governments to deny, reduce density, or render infeasible housing developments. So right there, they don't want local government to be able to do those things anymore. And furthermore, if a project is subject to Senate Bill 35, there's no discretionary review. It's basically a building permit application, which is pretty daunting stuff when you're talking about potential subdivisions. So the town's Planned Development District Chapter 17112 has served the community well for many years. It has guided developments such as Canyon Village, but it needs to be understood that the rules have drastically changed, that it's not just the purpose of these legislation, it's what they do. And probably the key provision is that under these state statutes, the only way you can review developments and change them is if you have objective development standards. And I won't go into chapter and verse about what those are, but suffice to say it's the type of black line standards, things like height, setbacks, lot size, etc. And in our planned development district, we have a lot of what would be considered subjective standards. Now, that process has resulted in good development that's appropriate for the town of Fairfax, but it's a long-term process. It involves phased application, submittal requirements, and we don't have that option anymore. We're supposed to let an applicant of less than 150 unit subdivision know within 30 days everything that could potentially affect the viability of that development. So what we have done, and we've explained this to the commission before and brought this more conceptually to the commission before, is looked at this Planned Development District chapter and said, what would it take to modify that to bring it into this brave new world of objective development standards? What we brought to your commission tonight is the first look at that. This is, even though there's crossouts on the existing language, this is strictly almost conceptual level discussion, but it's to give you something to see for the first time the changes between what we've previously been using and what staff's first attempt at creating objective development standards are. The other thing that we're doing is, whereas previously, and in staff's opinion appropriately, you would start with general development concepts and go to the specific as you refine the proposal, now you have to have all the information up front that would be used to deny, reduce the density of, et cetera. And so that's another thing that we are doing with the overall revamping of that chapter, is to say, okay, all the information that we would have asked for in this phased approach, we now have to have up front so that they have to give it to us with their application, and then we can tell them whether or not it complies. Given the time tonight, my recommendation is that we don't even get into that. The real meat of what staff is recommending in the staff report is just one section, 17.112.040B. And you can see that on page 5 of your staff report. And it's basically changing one sentence, and what it does is it applies a slope density table. And when staff looked at various planned development district parcels, and there was a question about whether their development potential had been extinguished. There are two parcels, one of which almost certainly has not had its development potential extinguished. It's currently on the market, and in California, there's no such thing as a landlocked parcel, and in today's hyperinflated real estate market, parcels that previously didn't pencil out may well. You combine that with a lack of objective development standards, and you have a vulnerability of somebody coming in with whatever they decide they want to do, and we lack the ability to change it. what the slope-based standard does, this 17.112.040B does, is more or less apply the type of density that we've done in non-PDD hillside parcels in the town, where what it says is that if it's a 10 to 19.9% slope, it's 2 acres per unit. If it's 20 to 29.9% slope, it's 5 acres per unit. And if it's 30% and over, it's 10 acres per unit. Now, I have to clarify that density is not the same thing as minimum lot size. What density allows you to do is, say, if you have a 20-acre parcel and it's more than 30% slope, it says, hey, you can put your houses, the 2 houses that 1 unit per 10 acres would have, side by side on the easiest access point in the lot that involves the least amount of grading, the least visual impact, the least impervious surface, all the things that would eventually be covered in the rest of the chapter. But it lets you put the building areas side by side on a very small lot and then retain the other 18 acres as permanent open space. So this is another beauty of having a chapter that's not necessarily conventional, that says 1 house and find a 10-acre parcel and it's going to go on that. This says you can cluster it on the most development-friendly portions of the site. So that's what staff is recommending that your commission review tonight and pass a resolution recommending to the town council that we include this new provision, we modify this one provision in chapter 17.112 to provide this slope-based density standard. And then we can take whatever time it takes to go through the rest of the standard and have this serious discussion with community members about what's appropriate for Fairfax and how we go through this process of creating objective development standards, being that are the few tools that we're left with. If you have any questions, I'm happy to answer.
I have a comment more than a question. I like your approach, and I particularly like...
Comment.
You're making the connection with land values.
I'm going to interrupt you again. Comments are going to come after the public hearing. So if you have a question for staff, let's go with those first.
Okay, no question.
Referencing your Exhibit A of your proposed ordinance, is that on the maximum residential density, is that gross acreage or net?
Gross.
Thank you.
So I had a couple questions. We don't, one of the things, and this will probably be in further discussions, but one of the things we haven't discussed are the current PDD zones in town, where they are, some kind of discussion on, what they involve, are they built out, that type of thing. That would be useful, because I'm looking at the map and what I see as identified PDD zones, so kind of a little discussion on that would be helpful. But the question that I had is the chart that you have.
Cindy, can you move your mic closer to your mouth?
I'm not one of those that.
No, you're the opposite.
The chart has a slope for 2 acres. It's an average slope of 10 to 19.9. So what would be and maybe a dumb question, but what would be the density for anything lower than 10% slope?
This doesn't address that would be subject to other reviews. So it would be, this gets back to your question about which parcels. For example, the St. Rita parcel, which probably isn't subject to development anytime soon, but that area is less than a 10% slope. Similarly, the China Villa parcel, the
Mandarin Garden, right at the...
Mandarin Gardens, excuse me. Yeah, the CL, which is identified in our housing element, is providing 10 units, I believe, 10 or maybe 12. That's less than 10% slope, so that wouldn't be affected by this. So,
but I guess my question is, if we're talking about density and slope, why wouldn't we address anything below 10% in this chart?
Well, because this chart looks at the two most vulnerable parcels, potentially vulnerable parcels that are steeply sloped, and says, let's apply the type of density to those that precludes potentially a much higher density development application coming in. The flatland parcels, insofar as, for example, the Mandarin Gardens site is tied up with a housing element designation for housing, you can't simply say, well, okay, it's going to be that density. That's going to take further analysis.
So for every PDD parcel that has less than 10% slope, you need to do further analysis to determine the density restrictions?
Yes, I would recommend that we would look at things like, is it on our housing element for a certain number of units? And we would look at providing the type of information that we would ask for once the rest of the chapter is vetted and we get language that says this is what you have to submit.
Okay, so this is a partial density section then.
Well, it affects the more steeply sloped parcels.
My other question is, we've got a moratorium, so is there any concern with, because what you're asking is that we look to revising the PDD for one section of it, and then continue on looking at the rest of the code section. So I guess my question is, that doesn't have any negative impact or any impact to the moratorium? Just wanted to throw that out there to be sure.
No, the moratorium would remain in effect. It should be noted that the moratorium does not prevent somebody from submitting an application.
Understand.
Any other questions for staff? Okay, let's open up the public hearing, and please introduce yourself and let us know if you're a Fairfax resident.
Frank Ager, 13 Meadow Way. This new ordinance is a rollback of protections in the current planned development district zones. The agenda should identify the properties the management staff wants to upzone. Parcel numbers are insufficient. The people of Fairfax have a right to know what properties are on the chopping block. The purpose of this revision of the planned development district zone is to allow current open spaces and ridgetops to be developed. The new owner of the Meadowland open space wants to put 5 to 6 houses on the ridgeline. This huge upzoning is a project under the California Environmental Quality Act, and Fairfax must first prepare an environmental impact report before this upzoning goes through. You know, unfortunately, the staff and your town lawyers don't have the understanding of Fairfax's current PDD zone. The staff uses the fear tactic that the state housing laws mandate rezoning much of Fairfax. Since the parcel zone planned development district are fully developed according to Fairfax laws and approved precise plans of record and agreements with the developers, previous developers, there is no reason to amend or rezone these properties. If staff believes Fairfax needs a different type of ordinance, then they need to prepare a standalone ordinance for any new development they believe should have some type of planned district zoning. Do not throw out 5 decades of environmental preservation and open space protection. Thank you very much.
Frank, could I ask you a question before you leave the podium?
Yes.
So first off, one of the things that the planning director has recommended this evening is that we focus just initially on the table with the slope limitations. Do you have thoughts about that piece of what is being proposed? That's my number one question, and maybe I'll let you answer that, and then I'll ask you another one.
Okay. We just go by your agenda, which has been posted, and it says continued consideration of a draft ordinance. We were here last time, and you ran out of time, so we left. We're back this evening. You're looking at, this whole ordinance is on your agenda, not just one little line. I see no reason for staff doing what they think they're going to do because they don't understand how the PDD zone worked in the past and works. All the PDD zone properties are fully developed. There is no opportunity for more development on them.
What about the claim that the planning director has indicated that, some of these quote-unquote previously landlocked parcels are actually now penciling out potentially developable?
Well, let me answer that this way. Fairfax approved a subdivision of the Victory Village project for the Lutheran Church property. And you're ending up with a landlocked parcel that can never be developed according to Fairfax laws. That was a mistake made by your lawyers. They're landlocked. They can't be developed. They don't have 65 feet of frontage on a public street. So, well, and your other, I'm sorry, and your other question was, you've seen the stakes. You've seen the stakes at the end of Glen Drive where they're going to try to cut a road up to the top of the ridge. I mean, that property is undevelopable. That property was set in open space in exchange for the high density that the developer got from Meadowland. So what staff is saying is wherever we protected open space as a condition of approval and gave a higher density for the flatlands, that's no longer relevant, that we can't protect that anymore. That's ridiculous. Of course we could protect that. There's signed agreements about that parcel being open space for the development.
All right, thank you very much. I appreciate your input.
Okay.
Hi, I'm Susan Pascal-Baran. I'm here with two hats on. I'm with the Oak Manor Homeowners Association, and I was asked to come to the meeting tonight to try to figure out what parcels were close to us. We located a lot of them on the map, but I'm up in Manor View at the very top, and one gal was looking and couldn't figure out which parcel, so I was asked to come and try to find that out. Also, I am, as I told Michelle earlier, an open space enthusiast. I'm currently on the Fairfax Open Space Committee, and I just love the, I'm here in Fairfax since 1980 because the open space is extraordinary. It's just exceptional. It's like nowhere else in the country. I've been all over the country. I'm an artist. I've traveled. That's what I did for 30 years, traveled all over the country, and I always come back here and I marvel at it. And so I am so thankful that Ben is considering valuing the open space as a component of this, but I would just really like to recommend to the committee that you dig your heels in and you really look at all the objective standards and use those to retain your control. Don't let it erode. Let's make Fairfax what Fairfax has a vision. You guys are some of the most intelligent people in the country. I know. I go everywhere. And you have great values. We really value open space. So when I was watching the Heather Lee June 6th meeting, she mentioned that there was a lot of possible objective standards, including a percentage for open space, as well as FAR and a whole bunch of others. And she said, et cetera, et cetera. So really, that's where we can really dig in. And also, I think that there are mechanisms, as she said, and ways that we can really try to shape a vision for Fairfax as having these smaller homes where we can live sustainably and in harmony with our nature. And green, we are just have some of the most green-minded and acting people here. So I think that you guys are our hope, I'm pegging my hope on you guys, and I know you can do it because I've known you in different capacities. I know of you.
Can you wrap it up?
Okay. Anyway, you're my heroes, so please dig in your heels. You can do it.
Thank you very much.
Deborah Benson, Cascade Drive. I've lived here for 25 years, and I've seen the community come together and fight for open space. We all value it greatly. A year, 2 years, time flies. I was at a meeting where an open space committee member let us all know that open space behind Oak Manor Drive would be continue to be open space, and the public would be allowed to use the trails for 5 years. Well, it turned out that when the land was developed, there was a court order that guaranteed public access to the trails and the open space in perpetuity. But former planning director made a new deal with the new owner. So I think there's a danger in a kind of a dearth of institutional memory here. It's my understanding that the parcels that are mentioned, the steep parcels, have already been dedicated as open space in deals were made for density when St. Rita's and Canyon Village and Meadowlands were developed. So before we start going into this 10-acre parcel, which to my understanding is open space, and how we're going to allow development of that, I think we need to look into the history a little bit, and I hope that you all will do that.
Thank you.
I understand that your focus right now is about one line in some language, but I have a different set of comments that I'd like to make. I've been a homeowner here now for 2.5 years, and I've lived in Fairfax for 6 years, and I've been trying to understand sort of the history. And Deborah used a phrase that I was going to use, which is there does seem to be a lack of institutional memory and continuity between town government and other things that go on. And so in different conversations that I've had, things that I've been learning, it seems like there are some agendas that want to be more pro-development in this town. And I understand there's new laws from the state, and I'd like to see more dialogue if possible so that we can maybe close some gaps. If Frank has knowledge that other people don't have, it's peculiar to me that someone with that much history in this town is not consulted, or something's not making sense. So, I echo everything else. We love the open space. I understand laws come in, people need to respond. But there seems to have been a push to change ordinances, to limit citizen input, to speed up processes, and it's just troubling. So,
thank you.
Mallory Guide, Willow Avenue. I do not want to see any zoning changed. I don't want to see Fairfax changed to where it's going to become more high density. And the reason that most of us moved here, and I've been here when it was a sleepy little town since '73, and I want to keep it not a total sleepy little town, because that's a done deal already. We're not going to go back there. But I don't want it to get worse. I don't want it to be Mill Valley. I want it to be Fairfax. And if we have to fight to keep it that way, I want to do that, and I want you guys to do that. I also want to suggest that when we have these ticket items, that they're not at 12 o'clock at night. People leave. They're important items. You're going to rush through stuff because everybody's tired, and I know you guys are. So can we, whoever's making the schedule, I will be glad to help them, okay? Because it needs some help. Thank you.
Thank you. Not seeing anyone else. Oh, we got more. Come on up. Could you put the mic on?
Hi there. My name is Lauren. I've lived here my whole life. And I do remember when it was a little more of a sleepy town, and I've since accepted that more people have moved in, but begging and pleading that we do not create any more density here. I think it's downright unsafe. And I don't want to see my hilltops filled with houses. I do pet care, and I walk dogs, and I use these trails every day. And I like to see them respected. That's what Fairfax is about. And I appreciate you just keeping that. I appreciate everything that Frank has done for us here to keep Fairfax what it is. And I'd like to see that continue and to have him be respected for the work he's done here. And for good reason. I think we all know why and what he's done and why he's done it. And we all get to enjoy what he's done here. And we need to respect him and the work that he's done. Thank you.
Thanks a lot. Okay, so I'm going to close the hearing. Oh my gosh, midnight. And bring it back to the Planning Commission for like the briefest of discussions. And maybe I'm going to start. And I'm going to say I am confused because from where I sit, I am seeing the motivation of this effort as being to protect our open space. So when the public comes in and takes what this effort is in the opposite reading, I'm very confused. And I really appreciate, Frank, your advice. I think it's a good thing that we aren't getting into phase 2 that you saw in the packet tonight, because I think we do need to slow down and be a little bit more strategic in how we look at this from an overall perspective. At the same time, and I'd really like some input from the other commissioners, I fail to see how the particular changes to the slope and maximum residential density that are specifically identified in this phase 1 piece that the planning director's asked us to look at today would create more density.
Under the existing ordinance, so this is attachment A3, it says existing zoning language, chapter 17.112, under .030 general standards, item A1, no planned development district shall include less than 5 acres of contiguous land unless blah, 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 blah. So you do a comparison between that and the proposed density range, which goes below 5 acres, and your net yield is greater than what is currently allowed. So that's the connection.
Could you repeat that?
Yeah.
No planned development district shall include
no planned
less than
development
5
shall
acres of
include
contiguous land.
Less than 5 acres, unless the planning commission or town council find that property less than 5 acres suitable for blah, blah, blah. So there's your standard. Your standard is 5 acres, and the new proposal has for slopes of 10 to 19.9 is no? I'm wrong? Okay, well, let Ben talk then.
And again, it's always subject to interpretation. My interpretation of that is that the parcel size has to be 5 acres, but that the density is established through the review. So the idea is that we're not applying this very detailed, comprehensive process to smaller parcels. But it doesn't say that the density shall be 1 unit per 5 acres.
On the page 1, isn't there a limit that you can't have a parcel less than 5 acres and have it be a PDD? You cannot be less than 5 acres and be considered a PDD, isn't that correct?
Correct, yes. But again, that's just simply saying that it's inapplicable to parcels that are less than 5 acre in size. It doesn't say what you can do with that parcel.
Well, then what is the general plan density ranges then? Because that's the other reference under 040A. It says the adopted general plan. And so is that where the idea is coming from, that it's more intense with this new chart?
Are you still looking at A3?
Now I'm on page 2 at the very bottom where it says residential density policy, follow the adopted general plan. And so that is, are they taking this chart, comparing these parcels to what the general plan density range is, and then comparing it to your Exhibit A and thinking that it's more intense?
We would need to look at the general plan, but I believe, hearing the comments tonight, that the idea is that these were already designated as open space as part and parcel of the overall developments in their area when they were one parcel. And that comment was raised previously, and staff has researched it. And looking at the subdivision map, looking at the deed records applying to individual residential parcels, there is no stipulation in the Meadowlands subdivision that be open space. So if there is information, files available, I would love to be corrected in my institutional knowledge, but I'm just simply saying that if you don't have it designated as open space in recorded documents, then there's something that's missing from that loop of locking that in as open space.
That being said, it seems to me that the intent of the action you propose is not to maximize, but rather to limit the extent of development on sloped parcels. Am I correct on that?
In the parcels, in the two parcels that are directly in question, the slopes exceed 30%. So what this in effect would do would be to apply the lowest density range.
The lowest density range possible.
Contained anywhere in the town code, which is our UR10, 1 unit per 10 acres. It preserves the ability to cluster development.
Exactly, and it preserves at least 9 of those 10 acres as open space undeveloped.
At least.
And so I don't understand why people are saying that you're trying to maximize development on a parcel.
Okay, so further discussion?
I have a question back to the institutional protections. Should they exist, these protections would govern the new state laws?
Yes, if a parcel had the designation that basically identified it for open space.
In a deed recording.
In a recorded deed.
Yeah, and now, that, when you get into the fine points of the law, obviously we would defer to our town attorney, but in terms of here's where you get to build, here's what's open space. But generally speaking, when you have that, there's a notation on the subdivision map that says open space. There's a recorded document that says, developable area, open space. For the Meadowlands parcel, it simply doesn't exist. It's not recorded.
It's not recorded. So what would happen if tonight we said, if we approve this proposal, what are the next steps for that, and how does that work if somebody like Frank does come forward with documentation after the fact?
That would be a hypothetical. Again, this is a district-wide regulation, so it's not specific to a parcel, and that point needs to be clearly understood. Right. If that land were locked up, if there were recorded documents, et cetera, then those provisions would still apply. It would simply say that, hey, if you've got a steep slope, that would be the maximum in any event. But if there's a legal document that says that's permanent open space, that's permanent open space.
Okay, so we won't negate any existing protections if we recommend approval for this? Okay, thank you.
One other point of clarification, if I may.
Just hold on just a second.
Okay.
Frank, I'm not going to open up the hearing, so.
I just want to tell you for your own knowledge that what your staff is asking.
You have your cutoff switch.
He's not on the mic.
Oh.
Thank you, Frank.
You need to understand where this whole thing is going.
All right, I'm not opening up the hearing.
You don't have to open the hearing. I'm just trying to tell you to please don't violate the law.
Oh, thank you.
Read your agenda. It's really clear. You've got to repost your agenda if you
All right.
check with your lawyer.
And one more point of clarification, we're talking about slopes and not specific parcels here.
That's correct. It's an area-wide
Thank you.
regulation.
And I guess I'll disagree with Frank. I think that because we have noticed this particular aspect of what we're discussing, that we're not violating the Brown Act. So you and I might disagree on that. Commissioner Rodriguez.
So I do have a question about whether the parcels that are in PDD received a notification of this agenda item.
Yes, they did, all over 900 of the properties themselves and everybody within 300 feet.
Thank you.
Other thoughts?
Since we're proposing to only address this one item of the slope and maximum density, is that correct? It's the only item that we want to, do you want a recommendation, or are you looking for an action? Have I not read the reso? Can you clarify that?
So
please?
on
Exhibit
phase
B.
1, on page 4 of the staff report, it indicates that staff recommends immediate consideration for recommendation to the town council, specific text creating objective development standards for the overall development density in the PDD zoning district. I take that to mean that they want us to
take an
decide
action.
whether or not we're going to make a recommendation to the town council on phase 1 tonight.
Yes, and also what we would be doing here is limiting the potential development of these sites based on the slope, not increasing any potential density, but limiting to the minimum level. And I agree with you, and I'm willing to make that motion.
Well, maybe we are there. Is there a second?
I second the motion.
Motion Fregoso, second Gonzalez-Parber. All in favor?
Aye.
I need a point of clarification.
Okay.
So just as a point of clarification, are you motioning on attachment B and attachment 1 to B? Is that what you're motioning on?
Let me look again.
And is that what the director is asking us?
I'm sorry,
Yeah.
what documents did you refer to?
Attachment B and attachment B1, Resolution 2018-24. Is that what you're motioning on?
I believe so. Let me take a quick
Okay.
look at it. Okay, hold on. Entitled
Okay, we're not taking public comment anymore.
I believe that is what I would be referring to, where we allow only one dwelling unit on 10 acres at a 30% slope.
Or greater.
Or greater. one dwelling unit for 10 acres.
And then the clarification that the
Could you please keep it down back there? Thank you.
Director's coming back with attachment A1 in the future, or?
No, this would be going to the town council. So the recommendation is that you adopt a resolution, and the resolution number is 2018-24. And that's recommending the town council adopt the attached ordinance, which is attachment 1, ordinance number XX.
With Exhibit A.
Yes.
But then what happens to attachment A1, which is later? That's the one coming
Yes.
later. And when's that coming? Or when do you want comments on that, I guess?
Yes.
Later.
Later.
Yes, later.
Okay.
In 2019.
Okay, so I will make.
We have a motion and a second?
We haven't got a second yet, and before we get a second, there's one little typo in the third whereas clause on attachment B in the resolution 2018-24. Whereas the purpose of this resolution is to make a recommendation to the town council to adopt an ordinance to update, blah, blah, blah. So is there a second? And would you accept that?
Yes.
Minor typo change, okay. Is there a second to Commissioner Fregosa's motion?
I second.
Okay, so we have a motion from Commissioner Fregoso and a second from Commissioner Gonzalez-Parber. All in favor? You guys are going to have to be quiet because we are looking at the packet. Okay, we're the Planning Commission and we're talking, not you guys. So I would like to hear whether or not we have... Hello, you are now the public who is speaking over me. Don't make me use my gavel. So I would like to hear, we have a motion and a second. All in favor?
Aye.
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 Any opposed?
No.
We have one opposition. Please be quiet, you guys. And
No.
we are making a recommendation to the town council pursuant to phase 1 of the packet. And we have one vote, Commissioner Rodriguez, in opposition to the proposal, and everyone else voting aye.
Can I just ask Commissioner Rodriguez what your opposition is, if you don't mind telling us? Is it something we overlooked, or?
Well, I think I just needed a little bit more information about the general plan densities relative to these densities and what?
Gotten that for you if we had known ahead of time.
All right, let me just hello, Commissioner Rodriguez, could you finish your sentence? And Planner Neal, could you please not interrupt? Thank you.
And I'm a little concerned about the other two attachments, A1 and A2, and when they're going to be coming back and how it relates to kind of process.
Okay. Thank you. We're done with that one. And we are on to the next item.
To the minutes.
Well, I think there are commissioner comments anyway.
Oh, Commissioner Swift wanted to comment on...
Sonoma thing, but
We'll do that
hold
when
on.
we get to that. We're not there yet.
Hold on.
The agenda.
Is it minutes first, and then
I gotta find mine.
Commissioner
No,
comments?
then it's then director, then planning director, then commissioner comments.
Minutes, then.
Can you hold on just a second when I get myself together? Thank you.
Read the minutes.
Well, you can't read them now. You should have read them beforehand. I'm not going to wait for you to read the minutes.
I've been reading.
All right. Next, we have the minutes from October 18th, November 15th, and the November 29th meeting. Did we already approve the October 25th minutes?
The October 18th was the only set that you didn't have enough people, you didn't have a quorum to act on. So you did approve the October 25th minutes.
All right. Are there comments on the October 18th minutes?
Yeah, it's...
I have one, which is Valerie Hood. His name does not have an E at the end of Valerie. On page 1. Anybody else with any comments on the October? It does not have an E at the end of Valerie. She does not spell her name with an E. All right. So they've spelled Valerie's name with an E. Her name does not include an E. Okay. Any other comments on the October 18th minutes?
I was absent, so I cannot.
Okay. Of the commissioners who were present, which would include Commissioner Gonzalez-Parber, Commissioner Rodriguez, and Commissioner Swift, are there any other comments?
Just clarification on page 5. It says Commissioner comments and requests. Commissioner Gonzalez-Parber asked about time limits on parking. I was asking for an explanation for public knowledge. So if it could just be clarified that I wanted the public to hear an explanation.
Any other comments? All right, with those changes, do we have a motion to approve the October 18th minutes from one of the commissioners who was there?
I make a motion that we approve the October 18th minutes with the corrections so stated.
Second.
All in favor?
Aye.
Aye, the 4
Aye.
commissioners who were here, who were present, are all in favor. Okay, let's move on to the November 15th minutes. Any comments from those that were present? Commissioner Fregoso, Commissioner Gonzalez-Parber, Commissioner Rodriguez.
Changes on page 4, Commissioner Rodriguez. The existing ordinance, it should read, the existing ordinance allows 3 medical marijuana dispensaries. To amend this ordinance depending upon the number of, oh God, forget it, it's too late now. Whew. No, just, no, I don't have any changes.
On page 2, the member of the public listed as Teresa Bryan, Fairfax is Patrice Bryan. I don't have any other comments.
I just have a teeny thing on page 4. Commissioner Fragoso, they're talking about, thank you. They're talking about 6 plants per property and not 6 plans. So it's plants per housing unit on that property.
Okay, any other comments or changes on the minutes from the November 15th meeting? Anyone who was at that meeting care to make a motion to approve these minutes?
I so move.
Is there a second?
Second.
Motion Fregoso, second Gonzalez-Parber. Of the 4 of us who were there, all in favor?
Aye.
Any opposed?
Aye.
Okay.
I in favor.
Everybody of the 4 that was present is in favor. Moving on very quickly to the special meeting, the November 29th minutes. And most of us who are here were there. So does anyone have any comments or changes to these minutes?
On page 8, Commissioner Rodriguez, 1, 2, 3, 4, 5, 6, 7, 8 bullets down. Second line, it says, not on ridge lines, flood zones, or near a mural. I don't know what I said, but I know it wasn't near a mural, because this is about antennas, so maybe just delete it?
Well, I think the discussion was we had discussed. I had brought up the question about whether you could put antenna. We have murals downtown in the historical area, and whether we could put them on there. And we wanted not to be able to touch them, so I think that may be where that came from.
Historic, just near on a historic mural, or
however you want to.
You just didn't want them to mess up a mural.
Right. Okay. Yeah, that's fine.
Any other comments or changes for these November 29th minutes?
Did I, on page 4, third line from the bottom, Commissioner Swift, Green, Fragoso, and Chair Newton stated they preferred a use permit process over a business license. I thought at that time we said we preferred the business license over a use permit.
Where are you?
On page 4, at the bottom, 3 lines up, Commissioners Swift, Green, Fragoso, and Chair Newton.
Preferred the business license process.
Preferred the use permit to a business license, and I think we, at that time, had reversed it. And today I reversed myself again and said I was willing to do the use permit.
Yeah, I think it was, yeah, this was clarified at the time.
I have gone back and forth on that.
So page, were you done? I'm sorry.
I am done, thank you.
Page 7, Commissioner Swift, 1, 2, 3. The third bullet, the third bullet down, she asked how equipment manufacturers would provide evidence regarding the ambient noise levels from different equipment. What I was referring to is different equipment provided by different manufacturers, because the piece of that draft spoke to a singular manufacturer being able to validate the noise level on potentially equipment that could be provided by different manufacturers.
I've got Valerie Hood's name needing to be spelled correctly on page 7 as well. Any other comments, changes, suggestions, and maybe from any of us that were present, a motion?
I move that we approve the minutes of November 29th, 2018, as stated, with the edits made by commissioners.
Is there a second?
Second?
All in favor?
Aye.
Any opposed?
Aye.
And Commissioner Caroline not voting because she wasn't there, and unanimous with all the rest of us. So minutes are done. And now we get to go to, oh, goody. Oh, before we leave minutes, just FYI, I was looking online We have the packets online in the historical archive, and it looks like we're missing the October 18th meeting archive. It just, because we had 2 meetings in October and 2 meetings in November, it looks like just one of the October meetings got up there.
Maybe because we had not approved the minutes?
Well, we have usually the videos up there. There's not even an entry. All right, so my favorite part of tonight's meeting is now going to be the election of a new chair and vice chair. Or maybe just I'll settle for an election of a new chair. And I don't know if it's appropriate or proper, but, I have a recommendation.
I have one too. I was going to recommend Commissioner Michelle Rodriguez.
For chair or vice chair?
Sorry, for chair.
Well, I was going to recommend Commissioner Swift, who has served as our vice chair this year, as the chair.
That's what, and I was going to recommend Commissioner Swift as well. But I would recommend Commissioner Rodriguez for vice chair.
Yeah. That would be fine. I agree with that.
So I'll leave the chair part separate. On the vice chair piece, and I don't know if this is doable, but not all of us are here. So Commissioner Green isn't here, and I know last year there was some interest there as well. So I was thinking that perhaps the vice chair could wait until the next meeting if we're all here. I don't know if that's doable.
Well, I was going to ask Commissioner Rodriguez if she's even interested in being the vice chair, if that's something you would like, because I agree with Commissioner Swift that the last year when I was nominated as the chair and Commissioner Swift was nominated as the vice chair, we had an indication that Commissioner Green was also interested in being the vice chair. And so since he's not here and I don't know if he's still interested, I just want to make sure that we all have our say and
Yeah, thank you. I think we should wait, and I think that would be great to hear.
And would you even be interested in that role if it turned out that way?
If he expressed interest, then no. I think that he's got longer history than I do.
So how do folks feel about putting off the decision as to the vice chair until the January meeting, but maybe allowing us to move forward with the nomination of the chair at this point?
Our regulations stipulate December. However, if that is put on the agenda for the first action item at the next meeting, I don't see any harm in it. It's a no harm, no foul situation. So the challenge would be if the chair, for some reason, was unable to attend the next meeting, but that's not going to happen, correct?
Life happens.
I'd be willing to be temporary vice chair until the next meeting, and the vice chair would be elected. Ha ha ha. In the eventuality that some, just, I don't know. I could self-nominate, right?
In the past, when we've had a situation when the chair and the vice chair were not available at the meeting, we've had like the previous chair the meeting. So we have had precedent in that situation.
There's probably a Roberts rule that attaches to that. I was just pointing out the possibility of, and it would be an unusual possibility, but I'm sure there's no problem.
All right. Well, then I want to move to elect Commissioner Swift as the new chair of the Planning Commission for 2019.
I second the motion.
All right. And I take it that Commissioner Swift is amenable to this. Ah, sucker. All right. All in favor?
Aye.
Aye. Unanimous. Thank you, everybody. And we'll agendize the vice chair as number 1 on the meeting for January. And then it looks like we do have the planning director's report next.
Just in terms of items for consideration in January, we do have a tree training session, and I believe 3 individual applications.
Yes, projects, there's one I might be able to put off.
One thought we were considering was if we had to add more ordinances, et cetera, that we might look at January 31st, the last Thursday of the month, to add a meeting. We're hoping to avoid it, but we're going to be moving into the active phase on Marinda Heights very shortly, and we would hate to deny the public their opportunity to speak fully and at length by cluttering it up with other items if that were to be the agenda item. So it might be good just to have a separate meeting for a kind of an overview discussion, a process discussion.
When do you think we're going to get cannabis back?
That's a good question. There's some heavy lifts associated with coming up with the code language. So as quickly as possible, certainly the commission has moved that discussion far enough now to where I think we can work on language, but it's up to the attorneys to really start crafting that, and us to kind of, it takes time when you're rewriting, or not, well, A, rewriting existing language, and B, coming up with new language from scratch in so many areas. So I would anticipate within 2 months at the latest, but given the holidays, et cetera, it might be a little bit daunting to assume that we would hear that at the regular meeting on the 17th of January.
So you're thinking the 31st possibly for some type of workshop, public meeting?
Correct.
Something. Do you want to see if we're available now?
Absolutely, if you have your schedule planners.
I don't know if I'm available.
Then maybe you can email us.
Okay.
That'd be better.
Okay. I will contact the commission and request that they look at their day timers, et cetera.
So 3 applications and a training session.
Correct. And appointment of a vice chair. And that's it.
Okay, thanks. Does anybody else have feedback for the planning director about the availability on the 31st?
I would have to get back to you. It's too far.
Okay.
I'm available.
All right. And now commissioner comments.
I wanted to invite everybody to the American Planning Association's National Conference, which will be held in January in San Francisco. It's pretty exciting. It's because a lot of other states have really good public policies on different topics, and then also, great cities, even within the state, get to showcase their work, and it's kind of the best of the best. And it's here in San Francisco, which you don't often see, so. I think it's the 21st. I can send you the, I'll email you the schedule.
Commissioner Swift, you had something you were going to share with us as well.
Yeah, and I'll make this shorter than I was going to make it, considering the hour. I went to the 35th Annual Sonoma State Planning Commissioners Conference, and it was really good. I left everybody, and I can, a one-page from the website that, and you'll have the link up at the top. It'll show you where to go to get that, but it has the presentations for 3 of the 4 presenters. But just quickly, the first one was how to be a good commissioner. The second one was wildfire recovery, a planner's journal. A former planning commissioner lost his house in the Tubbs fire. So he kind of went through that experience, and then kind of ended that with questions about in light of those things, how do you do land use? What do you plan? Do you go back and re-look kind of your zoning and where you put houses these days? There was a presentation by an attorney who's involved with the Valco Town Center SB 35 project in Cupertino. And her presentation was on large projects under SB 35. So I think Valco Town Center is like 50 acres and 2,000 square feet of, it's mixed use. And they're coming in under SB 35. And it's under litigation.
Did you go to that?
No, I was unfortunately detained.
I would have loved to go to the curtain presentation.
Yeah.
So you'll see, and a couple things, she talked a little bit about objective standards afterwards and some ways to look at objective standards, and we wouldn't have really large projects here. But 2 things she said about like SB 35 projects is that, an entity can look at putting all of their SB 35 objective standards and requirements in one chapter in your code. So put it all there, and it would address any project that comes through. The other thing she mentioned was on mixed-use projects, that an idea is to require the different aspects of that to be built at the same time. So if you've got office space, X amount of office space, and you're identifying X amount of housing units, you don't want to be in a situation where somebody comes in and builds all the retail or builds all the office space and then walks away without putting the housing. So just some different ways of thinking about those things. So it was really good, and she was a really good presenter.
Cindy, do you know the Swifts wrote the book on land use law in California, The Curtains?
Well, that's why it's called the Dan Curtin Law class or whatever, yeah.
Yeah, they are still the land
Right.
use standard.
And then the third, the last one was a local perspective on leading age transportation issues, and that I would have you all look at that. The presenter looked at transportation modes out, what their proponents promise with them, and then what the reality of them is today as far as, how they're fulfilling their promise, what their effect is on the environment, what their effect is on public transportation, equity issues. And they looked at ride-hailing, e-scooters, autonomous vehicles, started out with the ride-hailing and examples that what it's done to San Francisco is it's increased the number of cars in San Francisco, hasn't decreased them. It's increased transportation problems. It's impacted public transportation. So it's a really good a presentation on those aspects and kind of where they are now. And kind of the end comment was, don't change any of your land use or zoning to fit these models because they're not ready for prime time yet. So it was just a good conference. And hope you guys, take a look at those. Sometime in January, if it's possible, I thought maybe since it's been a year and we had a workshop last January to look at our priorities and what we were going to do this year. And so maybe we could just have a kind of at some point, a quick overview of what we came up with, where we are, what are we doing with the historical review, because I know you have somebody working on that, but we haven't had any particulars on that. So just kind of an overview of last January and where we are now. And then the last thing is I wanted to thank Mimi for the last year, her leadership. The first presentation at that conference was, and you get these at all the planning conferences, how to be a good planning commissioner, right? You always get that. And, the presenter talked about fairness, respect for others, public trust, and I think you've kind of been all those things for us and for the Planning Commission in the last year. And that describes you. It doesn't even describe your sense of humor or the fact that you've been having to herd cats for the last year. So I just wanted to say thank you.
That's very sweet. Thank you.
Also, you're an excellent chair. You really are. Even though you shut me down at every single meeting at least once.
But she did it with a sense of humor.
With a smile on her face, and it kept things moving. I appreciate that.
All right. Well, unless there are no other comments, I will...
Just one final comment. I want to thank staff for your dedication and your excellent work over this entire year. Very commendable. Thank you.
It's been a pleasure, and I have to say that, even with the controversies and the rancor and stuff like that, it's been so great working with your commission and the town council. Really excellent individuals and dedicated, and we're going to have to go through some stormy weather coming up, but I'm very confident in this group that we'll continue to forge ahead. And
the best 5 years of your life, right?
There you go. Yeah, sure.
All right. Do we have a motion to adjourn?
I motion to adjourn.
Second.
All in favor?
Aye.
Aye.
We're out of here.